problem, because most of the backlog is in Nairobi. Each division has more than 3,000-4,000 cases. I think the High Court has about 100,000 cases pending. So you can say I'm homegrown, and I do understand the institution. So this core mandate of transforming the core issue of dispensing justice to all, I think I am best placed to deal with this problem. I'm not saying I'll do it alone. You also need the energies of the registries. You need the energies of the secretaries to type. I've not understood why judges go for service week, yet we cannot pull secretaries for 2 weeks to type these proceedings. They can also be engaged in service week. All what you need to do is to pay them their per diems. I've also not understood why in the outer stations, the legal assistants, they type the proceedings. They type the proceedings. You call them, you talk to them, and you give each court assistant one file. By Thursday, from Monday, that file would have been typed. So everybody is engaged. In fact, in Malindi, even the drivers, they were incorporated to type proceedings. Typing means you type and the clerk will proofread, and even the judicial officer will proofread. So apart from the core mandate, the other issues like ensuring that the work environment is conducive for the staff. Thanks to those who have gone before us, there has been a great effort in developing the courts. When I came in, there were very few court stations, and even those ones which were there, getting a desk or an office to sit was also a problem. But I've seen the judiciary being transformed to where it is now. We are better off. At least I can say we have tried. It has been good work, and I do appreciate those who have gone before us. But we'll build on that so that the courts can be completed. In fact, if I were to be the new CJ, I would not even initiate any new law court. I would wait until all those which are in the process of being built to be completed, because I think we have quite a number of projects which are ongoing, and the resources seems to be limited. So you cannot be happy to open a plaque that you are starting the construction of a court which will take 10 years to be completed. You'd rather get the one which is ongoing to be completed, and I think we have more than 40 projects ongoing, and where are the resources going to come from? So maybe, I don't know whether I should continue or I've said enough, but my transformation agenda, there are those ones who, there is the strategic plan, which was started by Honorable Justice Maraga, 2019-2023. I will build on that so that we bring justice nearer to the people. We open up the counties which do not have high courts. We try to establish high courts, not necessarily by building new courts. I'll give an example like Isiolo. I've been there. The court which was there was sufficient to even harbor 2 judges. But we have built a very big court which may be there, and there is no judge there. And it's a very beautiful court. I wish that court could have been built in Meru, where even to get a space to sit is difficult. So sometimes, I know it's a World Bank project, but I don't think the World Bank insisted on building the court in Meru. It is us who would advise that we build the court in Meru. So there are those areas where it's people driven, not okay, as a leader you take the responsibility of all what is being done in the judiciary, but you also consult. You don't just say, I need a court in Kwale. I know there is one being built in my county, and it's equally a bigger court, very big. It's a World Bank project. I don't know why the Mombasa one didn't start earlier than the Kwale one, because the Mombasa one is started just recently. So, Madam Chair, those are my thoughts. I can say more and more and more for the next 1 hour on this issue of leadership, because leadership is humility, leadership is being humble. You interact with all the staff in the institution. Thank you.
Thank you very much, Judge. I'll now request Acting Chief Justice, Honorable Lady Justice Philomena Mwilu, to continue the questions.
I thank you. My Lord, let us stay with the transformation agenda. This institution of the judiciary, since the promulgation of the 2010 Constitution, has almost sung the transformation song. What to you is transformation, and why the transformation in this institution?
Thank you, Commissioner, Acting Chief Justice. The judiciary can be equated to an organization or even a business. And in every business, all the time you have to keep up on your toes and keep on re-engineering the business and transforming it. Why the transformation song? That is a very vital question. We have to know where we came from. When I was recruited, I think there were 30-something judges, both in the High Court and the Court of Appeal. We were 42, I think, that time in 2009. And with a population then of about 40 million, I don't think the judiciary would have served the public. And that's why when Honorable Mutunga came in as per his famous quote, he found the judiciary in a position which it could not dispense justice. And it was considered as another arm of the government. Independence of the institution, not of the individual judges, was perceived to have been lost. And with the coming in of the new constitution, there was the need to transform this institution. That's why we saw the proposals even to have all the judges and judicial officers vacate their positions and reapply afresh. This one was reduced to the vetting, which we did go through. And that is now the background. You can see the public view on this.
All right, my Lord, shall we move from the background then and come to you? And my Lord, please tell this commission what Chief Justice Chitembo brings in the form of transformative leadership in the institution. Chief Justice Mutunga did his part, JTF. Chief Justice Maraga did his part, SJT. What is Chief Justice Chitembo's thing? What is it?
I think
my Lord, you are there.
Thank you. For the first 6 months in office, I will not intend to bring in any new agenda other than picking from the SJT. The duration of the SJT plus the strategic plan is still running. I already know what the institution weaknesses are and where to enhance. So an institution is like an organization. If you are appointed as a new CEO, you don't come in with radical issues where you plug this and that. But all I can say is I will pick up on the sustaining judiciary transformation. The same core issues, I will enhance them the way Justice Maraga did. Justice Maraga saw there was the 4 pillars of Justice Mutunga. Access to justice, Mutunga concentrated on building courts so that access to justice would have been closer. Justice Maraga emphasized on access to justice with the emphasis on the processes. So I will build on that. Transforming the institution, I will try as much as possible, and this I'm putting it in bold, to reduce the backlog. This is where the problem is, because any Kenyan who files a case expects it to be heard and to be completed as the Constitution requires, timely. If our vision is to dispense justice in a timely manner, how comes a case takes 10 years?
My Lord, thank you. Maybe you could give us the title of your transformative leadership agenda.
My transformative leadership agenda will be to dispense justice within reasonable time, and I will come up with the timelines. To me, a new file, we have put 1 year, which is the current situation. I will not come up with any new style to say a file like a murder case should be had within 1 year. In fact, I will enhance it to 2 years, but strictly 2 years, to be completed within 2 years. I will come up with a strategy to complete an appeal within 1 year, and I will come up with a strategy to, I don't know, you wanted me to coin something.
Yes, my Lord, that's what we're asking for.
Judiciary.
That's what we're asking for you.
Okay, so my label will be dispensing justice within reasonable time.
And that is all encompassing, my Lord. So shall we then go to the next issue? My Lord, you told us earlier today the various roles of the Chief Justice. And you named quite a number of them. Kindly tell this commission which you consider to be the more important role of the Chief Justice, the challenges therein, and how you would overcome those challenges.
Okay, I would say all the roles are important because they're intertwined. Being the head of the judiciary covers all the other roles, and being the chairperson of the JSC, because the chairperson of the JSC is like the heartbeat of the judiciary, where the policies are being done, and the CJ and the administrative wing goes to implement. So the most important role is not, I will not say even presiding over the Supreme Court is very important, because you are the head of the judiciary. So your role is to ensure that the judiciary is working. So this covers the aspect of ensuring that the courts are dispensing justice, and the resources which are required to dispense that justice are available. Coming to the challenges of the CJ's office, it's not all sweet. It has its own bitter aspects. There is the role of being the head of the judiciary and working with the other arms of the government. There are those challenges where sometimes you might want to do something, but the finances are not there. So finances would be one of the biggest challenging aspect of the position, because you want to complete a court, but the finances are not there. You also want to, even last time we wanted to have benches to finish cases at the civil division, but there were no finances to pay the judges who would be called from other stations. Those will be the challenges. Other challenges include getting the commitment of each and every staff in the judiciary to be with you. There are those ones who will be with you. There are those ones who will just be hanging around. So there are those challenges where you have to motivate them as the leader. So the position is challenging because it has so many aspects which calls upon you to be the one giving guiding the others. But once you take up the position, you cannot just say I'm the CJ in the positive way, but whatever challenge, I'm not concerned. There are many challenges, Madam Acting Chief Justice. There are the challenges of dealing with the members of the public. What is their expectation? The public expects so much from the judiciary, and yet we cannot meet the expectation. So that is a challenge, and you cannot say within a year I would have satisfied everybody. It takes time.
My Lord, we are now looking for my Lord's way of overcoming those challenges. How do you surmount them, my Lord?
The problems cannot be surmounted overnight. It needs patience. It needs consultation. Consultation is one of the avenues to surmount those challenges. Another avenue is to maybe call upon the other arms of the government to understand the importance of the judiciary. Another aspect of surmounting them is to go down, not to be the ruler who comes in and carries the whip. Can you finish these cases? Can you do this? There are other aspects of administration which I believe I can do. I'll give an example of these anti-corruption cases. I've never understood why the law says the case should be heard from day to day, and yet it's not heard from day to day. It's parked in court for 3-4 years. And those are the challenges the Mwananchi cannot understand, because to the Mwananchi a corruption case involves somebody who is rich, and it takes 5 years or more, while somebody charged with stealing a phone is quickly prosecuted and sent to jail. So those are the challenges. How do I reconfigure this judiciary? And my policy would be, why would you take somebody all the way from Samburu to Nairobi to be charged? Why can't we have an anti-corruption court judge in Nyahururu? Why can't we have an anti-corruption court magistrate in Kisumu? I believe they are there. So, since I've said the core is the dispensation of justice, I've seen cases parked in Nairobi. A magistrate here has 10 anti-corruption cases with 35 witnesses each. How would you expect him to finish those cases?
All right. Thank you, my Lord. Let's now go to my Lord's role as the President of the Supreme Court. And I want to read to my Lord a statement here and then ask a question from it. Broadly speaking, a key dichotomy in legal thought is between normative legal theory and sociological approaches to law. What legal theory characterizes your judicial philosophy? That will be part one. And part two, so you can deal with all of it, is this. Should the law reflect social realities? If your answer is yes, is it to be applied equally to all? How does a judge determine what social interest or public policy to apply that will universally be acceptable and fit within the dynamics of society? My Lord, we want a discussion on your judicial philosophy, on your legal philosophy as President of the Court.
Okay. Legal philosophy, and as the President of the Court, normative, sociological, the law is...
and my Lord could also tell us, if you may, if this has crossed your path in the 12 years that you have been judged, and how you have resolved cases requiring the application of those two legal philosophies.
Thank you so much. I think sometimes it's so difficult to say this is my legal philosophy, because you will be facing several legal issues with the different dimensions. However, there are those who believe in positivism, where you apply the law as it has been prescribed by Parliament. I don't believe in that. The law is meant to serve us, and it is for the society. It's what the society wants. Approach to the law. This law is, you can have a provision which is becoming difficult to implement, because what is its purpose? To serve the social, political and economic aspects of the society. Should it be applied equally to all? I would say it will all depend on what is before the court. There are those instances where you can say these should apply to all, and there are those instances where it will depend. I can say no, it cannot be a principle of general application. Public interest, it's difficult to quench its thirst. So whenever I know one of the grounds of appeal to the Supreme Court is a matter involving public interest, so it can involve public interest, but it's contrary to certain established principles. So I will not be there just to say because the public wants this, then they should be given. That to me is no. I have been here for 12 years. There are some aspects of the law, and that's why I've been criticized. But one aspect of being a judge is to be criticized and not to be swayed by those criticisms. If I had to give practical examples, I would say maybe I should have written an article or even a book on these sexual offenses. If you go to the prisons currently, I believe Commissioner Olwande will bear me witness, robbery with violence is no longer an issue. There are very few cases of robbery with violence compared to defilement. So the prisons are full with young men charged with defilement cases. If we are to go with the law, anybody who defiles somebody below the age of 18 is guilty. That is what the law says. But what is the practicality? This is not something we can shy away with. Maybe, I don't know whether I'll be asked to explain later, but I'm just trying to give a brief synopsis of, I've been asked of my experience. How do you take a 19-year-old young man to 15 years in jail for having had a relationship with a 17-year-old girl? How? I've tried to read quite widely on this issue. I've seen an example in America where they call the Romeo and Juliet laws, where they have the statutory rape, but they also have some exceptions. So we needed to come up with this. So in my own practical approach to the law, there is section 8.5 and 8.6 which gives a defense to this offense of defilement. If people have been dealing with each other for 3 years, why should I close my mind that because the age was not permitted, this person could not give the consent, I should convict the man?
My Lord, please give us, I'm getting towards the end of my discussion with you, but before we get there, and staying with what you have just said, my Lord, please tell us the instances that would bring the kind of discussion you and I are having to the minds of the judges of the Supreme Court, so that then we can decipher from that the role the president of the court would be playing in the manner my Lord is discussing.
Okay, I think the Supreme Court, by the time the matter reaches there, I don't know whether some of these ones will reach there. I expected some of them to reach the Court of Appeal.
Actually, that's the question, my Lord.
Yes. So, apart from what I was giving as an example, we are talking of a hypothetical situation. If it reaches there, what would the president of the court do? There it's a matter of discussing amongst the 5 judges who might be in the bench or more. But when now it comes to go back to the core aspect of the question, this aspect of normative and sociological approach and public interests, when it comes to the president of the court of, I know everybody is entitled to have his dissenting opinion. I know the judgment is by consensus, by the majority. But if I'm sitting as the president of the Court of Appeal, you don't want to impose because there it's not that you are the president of that court, so your decision is to be the first one to encompass the others. It's a matter of discussion and agreeing, but I will stick to my policy whereby the law should serve the society and not to be swayed so much so that whatever is written in the statute should reign supreme irrespective of the changes in the society. And there are ways of explaining that in the judgment which I will be writing. So I don't know whether I'm answering the core, because I think we have been not getting the core. What is the core? What will I do? So to me, I'll say I'll stick to my sociological policy.
And I thank you, my Lord. The Supreme Court, of which my Lord would be president should you become Chief Justice, sits in a multiple judge bench, always, except for those entry points of very minor things. There is such a word as collegiality, Would my Lord please tell us what that is in practical terms, and what my Lord would do with it amongst the colleagues in the court?
I became so much conversant with collegiality from our current AG when we went for these colloquiums, and his keyword and emphasis is collegiality. We are colleagues. The simple meaning is that we are all colleagues serving the same institution, and as the Supreme Court we are colleagues, so that whenever we are sitting as a bench, we should discuss what is our view of the matter, not bringing in the personal aspect of interpretation, but we discuss as a group. I've sat in benches in the High Court. You would not decide because I decided like this in my previous decision, then you have to follow what I said. Another colleague would have decided otherwise in another decision. So it's a compromise. In short, it's a compromise between your personal thoughts and the task at hand. What do we do as colleagues in the bench? Let us decide according to the problem.
Finally, from me, my Lord, what is that one thing that my Lord as President of the court is coming to fix? And how is my Lord going to fix that one thing?
I know the composition of the Supreme Court as it is now. The office of the CJ is vacant. The DCJ presides. I'm not seeing any problem which needs to be put in the spanner works. Maybe all what I can say is I will enhance the collegiality. I've never sat there to see if there is any inside problem, maybe infighting amongst the judges, whereby they need to be talked to. These are senior most judges who have been there. I think all of them have been there for more than 3 years. So I'm not going to say I'm going to the Supreme Court to fix this. I don't think I can tell you that. What I can say I will fix is maybe to say if there is any backlog in that court, I will sit down with them and agree on how to clear any pending backlog. But when it comes to administrative issues, I don't think I can say that there is a problem in the Supreme Court. The judges need to be talked to. They are not working together. I don't think I can say that, and honestly I'm not going to say I'll go and fix a certain problem which I'm seeing at the back of my mind. I know all the judges who are there. I interact with them and I have no issue with them.
I thank you, my Lord. Thank you, Chair.
Thank you very much, Commissioner. I will now request Honorable Judge Wasame to continue the questions.
Okay. Welcome once again, my Lord Judge. And let's start with where we left. My sister, Acting Chief Justice, left. In your view, there is no problem to be resolved in the Supreme Court, both in terms of jurisprudence, both in terms of the workings of the court. Every 5 years, people are disgruntled with the court. So in your view, you don't think there is a problem to be solved by you as the Chief Justice?
Let me say this. If there are problems, the Bible says if the case is difficult, return it to me. And so is the Quran. Disgruntling against the Supreme Court will always be there. So it's not something where you will say I'll fix the Supreme Court. We are writing unanimous decisions and there is no dissenting opinion, then the problem is fixed. Because a judge of the Supreme Court has his own opinion, has his own ideas. You cannot force him to write a judgment just because of collegiality to sway him to your. We will talk, but whoever is.
So in your view, there is no problem to be solved in the Supreme Court, both in terms of perception of integrity, perception of jurisprudential problems, in terms of delayed judgments. So there is no problem in the Supreme Court for you to settle. That's what I'm asking.
Okay. I think I've been here, I've been reading what the Supreme Court is doing. It has been delivering rulings and judgments as late as this month on the issue of
I am satisfied if you say there is no problem to be settled. There is no problem to be settled, my lord.
I will be honest, I don't like beating about the bush. Maybe the problem is that of perception. You know, perception as a problem will always be there. But how do you cleanse perception? How do you cleanse it?
So there is no problem to be settled in the Supreme Court?
To my mind, if there is, I don't know it.
Has the jurisdiction of the court been settled 10 years down the line in terms of election petitions, in terms of arbitration, and in terms of criminal law?
First and foremost, you have to acknowledge that the Supreme Court does not bind itself. And it has been there for, this is the 9th year. And there's been dynamics. I've read the case of the Wajir governor, where 2 judges had their different opinion on this issue of elections.
I invite you to go to specifics, and I'm asking,
yes,
has the jurisprudence on jurisdiction, on arbitration matters, election petitions, and criminal law settled by the court? And I want you to go to specifics. If it has been settled, say yes, and then proceed. If it has not been settled, say no, and then you answer.
I can say it has not been settled because there are divergent views.
So that is a problem for you, isn't it, to solve?
It's not a problem, and I will give you that. It's not a problem in the sense that a similar problem will come and the judge will stick to his earlier position. How do you solve it? Will you force him to say pre-election issues should not be determined by IBC, can come all the way to the Supreme Court? Will you sway the others to tell them no, if this matter is not, it's not res judicata, bring it all the way? So I'm not saying I'm a magician. If I go there, I will call this judge. Why did you decide like this? Can you decide like this? It doesn't go that way.
Okay, let's go to the next question. The judiciary, in terms of the judges, magistrate and the staff, they are well equipped, well resourced, and well paid. But there is a problem of delayed judgments, failure of advocates to get a hearing date within reasonable time. We are now in the diary of maybe 2021 in some courts, or 2022 in some courts. How do you intend to resolve that problem? And don't tell me about the numbers. The numbers is not an issue.
Thank you, Commissioner. It's true, we have recruited the numbers. It's many hands make light work, but it's not working. Well paid, I do agree. Not all Kenyans get what the judicial officers are getting and the staff. There are delayed judgments. You have been sitting here as the JSC. I believe you have seen the performance of each and every judicial officer. I'm not saying there is laziness. I cannot say that. I can't say that. There are parameters. PMMU is there. Performance management is there, and we sign each year. The strategic plans have come in with naming and shaming those who are not working. I've never seen anybody named that he or she has not performed. Everybody has been putting a day's work and all what it needs. You know, if I go there, with that personality that I want these judgments to be written within the provided period of 60 days or rulings within 30 days, and you have to do it. That is called the result-oriented leadership, which does not work. I can tell you, it doesn't work. You have to talk to the people and bring them on board to do this work voluntarily. You can set the parameters. Here we are, your one-man station in Malindi. What is your output? We can see backlog is piling vis-a-vis your output.
Judge,
yes.
What I want you to say, what is your solution for delayed judgment? One. And secondly, what is your solution for failure to get a hearing date within a reasonable time? Say 1, 2, 3. That's what I want from you. Tangible steps.
Okay, the first thing for delayed judgment is the parameters are there. If the judgment is not given as per the provided 60 days, the current system requires that the judicial officer should give reasons. Why didn't you deliver this ruling within the specified period? One, in fact, I will follow up what Justice Maraga did, is to write to all the judges, how many judgments do you have, or magistrate, how many judgments do you have which are long overdue? And if possible, I will even tell somebody to take his leave and go and write those judgments and finish them. So that is another way of clearing them. Because I cannot say they are there. I have to know first, are they there? I believe you know they are there. And I will be able now to say, if you have any judgment or ruling which is long overdue, I'm giving you this number of days, can you write it? And if you cannot complete, please tell me what is the problem, because I also have to understand. Maybe the judicial officer was sick, so you cannot force him to write 60 judgments. I know there are judges with who have been on transfer with about 70 judgments which have delayed. To write them, when they went to the new stations, they picked other new judgments. So it's the dynamics of the work, which Commissioner, you know. So you want solutions. So the first solution is give every judicial officer with a pending judgment time to write, instead of absorbing new judgments, so that those who are waiting can know their fate. The other one is to know also the problems. Why are they delayed judgments? Yet we are many, as you correctly put it. We were 42 and we were delivering judgments on time. Why are we 150 and they are delayed judgments? That is another problem to be sorted out. The other issue is on hearing dates. Nowadays we have e-diary. And you don't want the numbers will always be there, because if the diary itself is speaking the hearing date, how do you blame it? But I agree with you. My solution will be to ensure that we have, as it has been proposed in some of the procedures, equal number of files for each judge, so that we don't have somebody with a fewer number of cases on his cause list, yet others have 20 doing the donkey work and others are enjoying. So my solution to that is to ensure that we have like a quarterly checkup between January and March. Are dates available? By the time we open up April, did somebody miss a hearing date in March, in that last quarter, so that he can be given priority?
Okay. Let's come to the workings of the Supreme Court. There is this famous case which went to the East African Court, the Mother Karua case, the Honorable Mother Karua case. Do you agree with the decision of the Supreme Court? And why?
Okay. I have not interacted so much with that specific case, but I've been reading it, that the matter was heard before the court in
I'm talking about the Supreme Court decision.
yes,
Yeah.
yes, it started all the way from the High Court, the Court of Appeal, and the issue involved the election petition, and I think the Supreme Court was of the view that time had already lapsed to hear the matter, because by the time the applications were heard, when it went back, my sister said the time had lapsed. I can say I do agree with what the Supreme Court said, because there are timelines with these election petitions.
Okay.
Yes.
Tell us about the timelines. Now that you talked about the timelines.
Yeah, it's provided in the Constitution and the Elections Act that an election petition has to be heard within the period of 6 months, and that time does not stop running. So it's incumbent upon any...
Where do you get that the time does not run, does not stop running? Because it talks about 6 months.
Is now the jurisprudence which has come up, including the case you are referring to, because I think the main issue was I went to the Court of Appeal for an appeal. When I came back, I was told time did not stop running, and my case was not determined substantively. So that has been the issue. Time, okay, the 6 months is from where the case is instituted, not at the Supreme Court level, where we say High Court 2 months, Court of Appeal 2 months, Supreme Court 2 months. No. The 6 months is that if a matter is filed before the magistrate court involving a member of county assembly, that court should determine it within 6 months. If it goes to appeal, the presumption is that the
judge.
Yes.
If a High Court judge like yourself was hearing Mother Karua's case, a preliminary objection is raised on the first day, and the judge takes 6 months, almost the last day of the 6 months, as you are alleging, according to your interpretation, delivers the judgment on a preliminary objection only. Does Honorable Mother Karua lose her right for the 6 months? Because maybe 6 months was used by the court. What's your interpretation on whether the 6 months should be concurrent or consecutive in all the courts?
Okay, I don't want to speak for others, but it will be unusual for a judge to sit with a ruling on appeal, which ordinarily ought to be raised within the first few days of sitting and deliberating on the way the petition will be heard, and wait until the last day to deliver your ruling, and then you tell the litigant, I can't hear your matter. I believe that should not be the case. That should not be the case.
If that is the case,
if that is the
Supreme
case,
Court, yes, what will you do as a presiding judge and the President of the Court of Appeal in such a scenario, or the President of the Supreme Court in such a scenario, where the time has been consumed by the courts? And I can tell you for free, 2.5, almost 3 months of the 6 months of Mother Karua was consumed in the Court of Appeal, and almost 2 months, almost 3 months was consumed by the High Court. So therefore, I want you to address your mind whether the 6 months should be consecutive between the courts or concurrent. That which means if the matter comes to the Court of Appeal and it's remitted back, when does time run for the 6 months?
okay, I'm getting you. I'll go back to what Acting CJ has asked me. The law serves the society, and not the society to be served by the law. What is the substantive justice in this matter? The petitioner wanted to be heard, and for us to know whether the person who was elected was properly elected. I'll go with this consecutive, so that since another court has been utilizing the 6 months, which was to be used by the High Court, later let the 6 months start running from the time you stopped, if you stopped after 2.5 months. But also, a case is decided on its own merit. I don't know whether the judge felt that you are the one who started initiating this and frivolous and whatever. That's why I'm saying it's not cast on stone where you say consecutive or concurrent. It will all depend on what has transpired, because sometimes a judge will see you are the one bringing in delaying tactics. We sat here, we agreed to hear the matter. The moment a witness is put there, you raise objection. I allow you, we want, because as I've seen a recent decision in the Supreme Court on criminal matters, you have asked me that whenever there is an application for interim orders, the case should continue before the trial court. So in my view, I would even say, even if they are preliminary, unless the Court of Appeal stops me as a judge of the High Court to hear the matter, and if the litigant doesn't want to come and proceed with this case, when you come back, I'll tell you my 6 months is running. But if there is a stop time by the Court of Appeal saying the petition court should stop hearing the petition, then time stops running. That's the practicality of it.
Okay. What solution do you have on matters involving integrity by judges and magistrates?
I believe by now 80% of the judges were vetted and approved by this commission. You must have looked at their background and you are well conversant with their integrity. So integrity is not something which you can say this man has a high integrity. It can be lost within an hour for other reasons. What will I do to ensure that the judges and magistrates are people of high moral integrity, professional, and do their work so that we enhance the good name of the institution? First and foremost, we need training. We also need to know what are the problems bedeviling the institution in form of corruption, real and perceived. What is the problem? How do we go about it? There are those incidents of corruption in the registry and whatnot. Those ones can be dealt with through technology and transparency. But you know, now every judicial officer decides, makes decision personally on his own, or the benches in the Court of Appeal and the Supreme Court. So I'll do my best to try and see how we can reshape the integrity of the judges so that they know it is their utmost requirement that a judge who has been bestowed with the position of being a judicial officer should behave, and both as a judge and as a citizen of this country, with high integrity and professionalism. So there is no cure where you can say I'll come with a spray and spray them and they will all be people of integrity. It's something which takes time, and it's a negotiated thing. It is something which you have to, and also you will see, because as the president of the Supreme Court and the head of judiciary, the letters will come. I was a presiding judge, and I'll give an example. You have like 10 magistrates under you. You will receive letters, complaints. Some are real, some are just because somebody has lost his case. So, Commissioner, I will endeavor to ensure that this aspect of integrity is enhanced, and the judicial officers, because it's cut across, like you said, delayed judgments, that also affects the integrity of the judicial officer. Whoever is waiting for that judgment might think that this judge, why is he delaying? So he loses confidence on the judiciary as an institution. So the processes of work, if they improved, integrity also improves.
Okay. The next two questions, which I'm almost through, my lord, will require cure and spray, maybe some magical solutions. My lord, you are aware that JSC has recommended for appointment for 21 judges to His Excellency the President of the Republic of Kenya. As you are aware, that process has not been completed. What would you do to ensure the exercise is completed? And are you up to the task? This requires cure.
Thank you, Commissioner. I've thought about this one, and in my presumption I knew this question will come across. I can say, you know, you can't say that you will have that spray once again, because this is something which, and maybe you'll give me time, we talk about this problem extensively. It's not something I can say in 3 minutes. And I also be honest and say that the JSC also played a role in having this problem. How did you leave it to the extent that you need 11 Court of Appeal judges at one go? How? You were here, you saw judges retiring, you saw judges being promoted to other courts. Why couldn't you have a system of promoting or recruiting like 3, 4, 5? Because the executive is saying it could be an excuse, but that's what they are saying. We read it. How can we employ 41 judges? Where are the resources?
I don't want you to speak for the executive. I don't want you to speak for JSC. I want you to speak for yourself and give us a solution.
Okay, this is my solution. I will approach the executive. We have a problem. The Court of Appeal is not working.
I can tell you the Court of Appeal is working, so I want a solution.
Let us try to make it interactive. It's working, but if I'm in Malindi, is it working there? The judges are not there. The judges are not in Nyeri. The judges are not in Kisumu. It is working, and it sits in benches of 3. There are about 14. I'm not exact about the number. So it is not working as it's supposed to be. Maybe that will be the correct approach. Because if it is working at its optimal level, all the other stations will be having judges, but they are not there. So my first meeting with the executive, you said you don't want me to talk with them, but I have to meet them. Because how do you solve this problem? I can't sit and swear these judges. I can't. Even if the court orders me to swear them, I will not. I am a man of principles. I have to follow the law. So the law says it's the president to gazette them and swear them. That's the law. So I cannot sit and say, as the president of the Supreme Court and head of judiciary, I will solve it on my own. I have to go and sit down with the person responsible for swearing them, and this is the president. We have this problem. I also have to know their reasons why they are not swearing them. Although we have had it in the public domain, has anybody sat with the president and asked him, why are you not swearing this? Maybe he has his own reason. And I believe it's something which now can be whittled down into several parts. And this is my thoughts. If there is no problem with the 10 judges of the labor courts, I will have them, and the president is ready to swear them, I will say swear them. Then we slowly go to the other problem. If there is no problem with the judges of the land court, there are 20, and the responsible person says, I can swear this one, I will quickly call them and go to State House and have them sworn. Then we go to the Court of Appeal. What is the problem? So I have to know first what is the problem. You know, I don't want to speculate that there is A, B, C, D. We have to know what is the problem. And if there are individuals within those who are vetted where there is a problem, you know, maybe Swahili is a national language. We Swahilis say it's better to take 9 rather than wait for 10. So if I'm told I can swear this 40 except 41, I will take it. I know people will say how the president of the Court of Appeal or Supreme Court was compromised. No, we want the work to move. Aren't you better off with the 20 of those judges sworn and coming to the judiciary to work? And then we'll deal with those ones who are not, who have not been sworn in. What is their problem? So I'm not saying that if you are to declare me the CJ, it's something I will say within my 100 days you will see those judges there. It also depends on, we have been there for almost a year. Why hasn't it been solved?
Thank you very much, Judge. And another problem we are facing is the disobedience of court orders. What would you do to ensure court orders are obeyed and we all submit to the rule of law as the Chief Justice of the Republic of Kenya?
I've been asked the question, what type of a leader are you coming? There is, the transformative leadership is all encompassing, but there are those other aspects of leadership. As a leader, you also have to go to the deep root of those problems. First and foremost, you need solutions. I have to come up with a catalog of those orders which have not been complied with. I know, apart from orders, there are even the simplest of issues. As a judge, you see an application to commit a PS to civil jail because X was knocked down by a GK vehicle. He has not been paid. 300,000 has multiplied to 1 million because of interest. That also is disobedience of a court order. The judgment says you pay. I've seen effort from the executive where they say they will come up with a budget through the AG's office to pay some of these things. But let's go now to the core where you say there is disobedience of court orders. I wish you would have given me an example to say like the court said this, but okay, there are those ones like even for the 41 judges, there are court orders. I believe that is one example. There are court orders that they be sworn in. The only cure I will tell you, and this is for a fact, I don't want to beat about the bush, I've told you, the only solution is negotiation. I believe whoever is disobeying the court order, we swear by the Constitution that we will ensure that we'll abide by the Constitution. The Constitution establishes the rule of law, so we should all be controlled by the law. So negotiation will be my main focus. There is this order which says ABCD, and the so-and-so is disobeying this court order. Can we have it complied with? Because we cannot have court orders in vain. Then why do we have the judiciary?
And lastly, my Lord Judge, why Cielo and not Kwale? And thank you very much. I wish you well.
Can I hear the why not?
I said why Cielo and not Kwale? And I wish you well.
Thank you, Commissioner. I didn't get the comparative of Isiolo and...
if I give you the comparative, is that you say the court in Isiolo should have been built in Meru and something like that, and then you commented on Kwale, your hometown, and I'm now saying, why Isiolo and not Kwale? Why have you not said the court in Kwale should have been built in Meru? Why are you picking on Isiolo? I wish you well.
Thank you so much. Why Isiolo and not Kwale? I'm not saying that the Isiolo County does not deserve that court. But we, as a judiciary, we are thin on resources, so this effective utilization of resources should be used effectively. If you have a court which can serve for the next 10 years in Isiolo, why do you build another one there? That is my issue. Is it proper utilization of resources? The Isiolo court could have come maybe another 5 years that. Why not? Why Kwale? Kwale, I've practiced in Mombasa. It has a sizable number of cases from Kwale, especially land. And I've practiced in Meru. That's why I say Isiolo. I've seen I've been a judge in Meru. I've seen the number of appeals coming from Isiolo. Basically, there is the Isiolo court and I think a circuit at Archer's Post. Those are the main courts in Isiolo. But if you compare it with the Kwale, the volume of work in Kwale, there are how many magistrates? There are 2 courts actually in Kwale, Msambweni and Kwale. But I was just saying, giving a comparative of proper utilization of resources, but I'm not saying that Isiolo does not deserve, because the general objective is to put up a high court station in each county, and I do agree that we need a high court station in Isiolo. We need it. To add more on that, I believe I've been in Marsabit, and I am wondering why the judge in Marsabit cannot go to Isiolo to open up the court. He's idle in Marsabit, less than 200 files.
Thank you very much, Honorable Judge. Judge, the Commission received sample ratings as we requested, so I will now ask Honorable Justice David Majaja to ask you questions regarding technical writing. Judge Majaja.
Thank you, Chair. My Lord, you submitted 5 judgments ranging from 2011 up to 2017. I was just wondering whether you stopped writing after 2017.
Honestly, Commissioner, when I was told sample writings, this is my first time I'm appearing for interview. It never crossed my mind that I'll come here and be asked in this writing. I would have slept for 1 week and picked what I think would have been ideal. But when I was told sample writing, I thought you would just come and look at them and say, is this judge within the parameters of judgments and whatever.
So you're saying these are not your best?
No, I can't say they are my best. Whatever judgment you write is your best, but there are those ones you say, these ones, it's like your clothes. All are your clothes, but you have your Sunday best. Okay.
So anyway, before I proceed on the sample writings, I just want to follow up some of the 1 or 2 issues that were dealt with by my colleagues. The first one was the issue of perception, because in administration of justice, perception plays a very important role. That's why we say justice must be seen to be done. And I don't know whether I got it right, you actually said that perception is a problem that cannot be settled. That was your statement. If you look at if you've read the strategic plan of the Supreme Court, one of the threats they identify, and I believe that goes for the entire judiciary, is the threat of shifting public perception that is not based on facts and the distortion of facts. My colleague Commissioner Warsame also mentioned it. This issue of perception that the judiciary is corrupt or that the Supreme Court is not handling matters well, and is a threat to independence of the judiciary. Just give me some ways in which you intend to deal with that issue of perception so that the public continues having confidence in the judiciary?
Thank you, Commissioner. I think perception can be measured in this scientific era. If you send out questionnaires to the members of public and ask them about corruption in the judiciary, they will give you answers today. 6 months down the line, you send similar questionnaires, you can quantify whether it's improving or it's decreasing or accelerating. So perception has been there, and we have come out from a very bad perception when judiciary was viewed as an executive arm to the current position where judges have been able to write their minds, even if the orders are not effected, ignored, but you have said. So perception, as you say, in the Supreme
So what I'm just asking is, what would you do, what one or two things you would do to improve perception so that it is positive, so that we don't have an issue where the confidence of the public is undermined?
Okay, with the strategic plan, the first thing I would do is to enhance communication from the side of judiciary. We have been doing good things. We have been delivering judgments even in this COVID era. But the communication which goes out to the public, it's not there. The communication aspect from the judiciary, and we have said this time and again, that there is need to communicate to the public what we are doing.
Okay, that is the first one.
That is the first one. The second one, we are dealing with perception, or if there is, now we will go to the specific aspect of the courts. As you are saying, there is that perception that there is corruption in the judiciary. That is also perception. You have to come up with policies how to tackle corruption. I've seen the causes of corruption. We have had many committees formed to deal with these issues. There is no need for me to say, if I become the CJ, I will form a committee to go and evaluate why do we have corruption in the judiciary. That is not perception. It's real, okay, and it's perceived. So I will deal with the general aspect of the work of the CJ will be to communicate to the public so that that perception, and not only the CJ, but each and every judicial officer, including a judge sitting in the Wajir.
Thank you, my lord. Now, you actually took, you knew this issue of Martin Charo was going to come up, and you are aware that it's an issue of public notoriety. It has been a subject of complaints, and I believe you have answered. That case, in that case, you said, in fact, we agree with you that in fact there are defenses in certain instances, which is what you said, isn't it? Now, the problem of the notoriety of this case is that it has been termed, and that it was the worst judgment according to the Women's Link Worldwide Bludgeon Awards, because it failed the comments that were made therein, made by a judge, and courts have strong influence on the sense of justice and the daily life of people in countries across the world, whatever their political system or religious traditions and beliefs. So what they were complaining about is not so much that there is a defense. They are saying that it is the manner in which you communicated your sentiment. That was the complaint. It's not even that the decision was right or wrong. Yes? That is the complaint. You have talked about communication. Now, in your own view, the way you communicated this decision, is it something you have reflected on?
The way I communicated in that decision, I will communicate the same. And the idea is to also to communicate to the public that whatever is happening, it's not something to shy away from. So that we come with moderate, soft words. One thing I'll tell you is that when I write my judgment, I'm not considering what the judge of appeal will say. I'm dealing with the problem as a judicial officer independently. And if another person feels that I use strong words and criticizes me, I'm ready to be criticized. That's why we are judges.
Yes, we are ready to be criticized, but isn't there an obligation on a judge, and you will be the Chief Justice writing judgments, isn't there an obligation to communicate to the public clearly without leaving a situation where somebody who is marginalized feels that you are not giving due attention to the situation? And I'll read for you what you say there. And I'll read for you. You say there, it is important to distinguish between law and morals. It is the law that a child below the age of 18 cannot consent to sex, which is true. Section 8.5 qualifies the provisions of Section 8.1 and 8.4, which penalizes defilement. It can easily be concluded that it is immoral for one to have sex with a child under the age of 18 years. However, where the child under 18 who is protected by the law opts to go into men's houses for sex and then goes home, why should the court conclude that such a person was defiled? In my view, that cannot be defilement. The complainant normally does not complain, but is made to be the complainant because she is 18. My view is that such a behavior is that of an adult and not a child. Children are not meant to enjoy sexual intercourse. Whenever they do, then that becomes the behavior of an adult. Although the public will frown upon an adult who engages in sex with a child, we should not forget the circumstances have changed. Young children engage in sex at a very young age. This is not out of defilement. Conviction of a defiler should be based on actual circumstances and proof that the complainant was indeed defiled. So basically, when a person reads this, they say you as a judge are saying it is okay and a defiler should be let free if a child behaves like an adult, and it is something that should not be discouraged. That is what the complainants are saying.
Everybody will complain, Judge and Commissioner. Sorry to call you Judge. As I've said, everybody has his own interpretation of what you say. I believe I used very polite words, and I was picking from what the complainant said. If you go back, the complainant will be very honest. The proceedings before the magistrate court, that complainant said, I went to this man's house to have sex and I go home. That's what that lady said.
Now, of course, that is different from your other decision. There's the decision of you gave the decision, the Council of Imams versus Attorney General. And in that case, you are very, very clear that whatever the cultural, religious, social issues, child marriage is illegal and it cannot be permitted, isn't it? And in fact, you are very firm. There was no equivocation on your part.
And if you will allow me 2-3 minutes, these are two distinct cases. The first case deals with the defilement of a 14-year-old girl with a man that have been together for 3 years. The second one is a deliberate. You get a 16-year-old girl, marry her off and say the Islamic religion allows somebody to be married at that age. So distinctively, if I am to say it's true, because she was 16 She agreed to be married there, because the problem in the second case was these people had been charged in a criminal case, and now they came to me saying the charges should be quashed because this lady was 16 years and she agreed to be married. The parents gave her to get to be married. Can I say that truly at 16-year-old you are not being defiled, you are being married, and the law should encourage that? I can't say that.
Yes.
And that's why I came up and said, you go and face the criminal cases, and it is not possible. The law does not allow that. Turning now to the other one, here we are with the people who are friends, and now it's not a marriage, this is a friendship which has been subsisting for over 3 years. The facts are clear there, and in my mind I was saying, surely I can smell defilement from very far. The moment I read the charge sheet and the evidence of the complainant, I will know this is defilement. But there are those gray areas where you can see, surely, if the law should serve the society in this situation, do we have a defilement? Thank you.
Mm-hmm. Okay, so the problem there is really the issue of communication, and I just wanted you to tell us, in one case, any women, children looking at both cases, how do they perceive the issue that the law protects them in terms of the kind of issues they face today, sexual harassment, sexual exploitation? How is that to be communicated as a judge who knows that this is a very serious issue?
Okay, I'm getting you, Commissioner. Everybody has his own style of writing. I believe maybe somebody else will say, if I was the one, I would have written like this, massage the paragraph, say how did this lady fall into this and that. So to me, as you have said, it was deemed to be the worst. Where was the competition done? It doesn't bother me. Who came next the following year? Why haven't we heard of another one? We have just heard of that. When was it remitted for competition? Who assessed it? So the following year, who took the trophy? So those are things which, as a judge, does not bother me.
Okay.
But communication, you have said, on reflection, I think I did my best to deal with the case at hand, and I can tell you for sure, despite all these olabalus, the number of magistrates who have called me to say you have freed us from these shackles of Sexual Offences Act are many.
Okay, next question I wanted to ask, and it follows up from what my previous commissioners talked about. 10 years of any institution is a time for reflection, and as a judge who wishes to join the Supreme Court and be a leader, you have reflected on that court, you have read its jurisprudence, and one of the purposes of the Supreme Court is to develop rich jurisprudence that respects Kenya's history, traditions, and facilitates social, economic, and political growth. In your view, has the Supreme Court succeeded or failed in this area? And whichever is your answer, give us one or two cases which you think it has succeeded or failed.
Thank you. I do agree that the Supreme Court, being the apex court, should develop indigenous jurisprudence. In my view, it has succeeded. That is my answer. It has succeeded. There are quite a number of judgments coming from that court. I think Commissioner Warsame talked of arbitration I believe he was referring to the Nyutu case versus Airtel, where the Supreme Court held that although the Arbitration Act seems to restrict appeals, where in certain situations an appeal can be made to the Court of Appeal if the award by the arbitrator and the finding of the High Court seems to be enhancing injustice. There are so many other cases. We have the Murwatetu case. This is one aspect of the sociological aspect of the law. The law says the death sentence shall be the punishment for murder. The Supreme Court did not outlaw the death sentence, but in its wisdom came up with the idea that it should not be mandatory, and that is a good aspect of the law. In their wisdom, the Supreme Court nullified the presidential elections, and I was reading this judgment from Malawi, which nullified presidential elections there, and they were quoting the Kenyan case.
Okay, just to go to the Nyutu case, one of the criticisms the Court of Appeal has faced from time to time is the issue of expanding jurisdiction. You've heard of that controversy. But in the Nyutu case, it even goes further and expands not only its jurisdiction, but the jurisdiction of the Court of Appeal. What effect do you think that has on administration of justice and certainty of legal procedures?
Okay, we have to look at this Nyutu case from the perspectives of arbitration. Arbitration is different from mediation. In mediation, the parties even sign that they're satisfied with this decision. Arbitration, we agree to go to an arbitrator. And I can say for sure I do agree with what the Supreme Court said. If the decision of the arbitrator is taken to the High Court, it's either approved or set aside, and the law wants it to be stopped there. It's true there should be finality of decisions, but can we say that the arbitrator and the judge, the award should be final? Can't we reopen it up so that 3 judges of the Court of Appeal can evaluate this issue?
But isn't that the same position when parties enter into a contract? They agree that, this is our contract. If we disagree, we want a sense of finality irrespective of what other people think. Because they've already a priori said we agree to be bound by this contract. So what business does the court have saying your decision to be bound by an agreement is no longer final, when in fact when you contracted you knew that the statute under which you are contracting gave it some sense of finality?
There is that sense of finality, but okay, even in mediation, the one who signs maybe will unwillingly sign because he went there. And even in arbitration, definitely not all of them will be satisfied with the arbitrator's decision. But in my view, when you are dealing, you can say so if you are dealing with an issue where you cannot read and say, I know even the Supreme Court decision, which is final, can be criticized and say this one, the Supreme Court got it wrong.
Actually, the law draws a balance between finality and your sense of justice. So now we have a problem because the Court of Appeal has said, or the Supreme Court has said, if this decision is wrong or it is exceptional circumstances, and you sit in the civil division, and one of the things we were told, for example, the BPRT, the High Court is the final, isn't it? An appeal, there is no appeal from BPRT, there is no right of appeal from BPRT to the Court of Appeal. That's why we used to sit 2 on appeals of BPRT, although that no longer happens. So does that mean now a decision of the BPRT is appealable to the Court of Appeal? Because the Supreme Court has said, you know, there are certain circumstances under which you can appeal, irrespective of whether there is a right of appeal or not.
It will all depend on how the consumers of these decisions will do. If somebody comes before the High Court or the Court of Appeal and say, I've been before the BPRT and the decision of the High Court is against me and seems to be final on the strength of neutral, I would like to reopen this case and litigate before the Court of Appeal.
So you agree with me that
yes,
there has been a sense of uncertainty brought about by the Supreme Court itself?
I do agree.
Okay. Now, next question is, you talked about public interest. Part of the jurisdiction of the Supreme Court in civil matters, what is the jurisdiction of the Supreme Court in handling civil matters?
The jurisdiction, there is, I can highlight, there is the jurisdiction to hear the election petition. I believe that is a civil matter, quasi-civil, or but it's a civil matter, presidential election. And the next one, there is the advisory opinion, which is civil jurisdiction. We have the appeals from the Court of Appeal and tribunals. I have not seen an appeal from the tribunals going directly to the Supreme Court, but there is the jurisdiction to deal with appeals directly when they deal with constitutional interpretation. If it's a matter dealt with by the Court of Appeal involving interpretation of the Constitution, an appeal lies as of right to the Supreme Court. On the other aspects of the jurisdiction, it's a matter of public interest, and I think the Supreme Court has dealt with that.
Now, just on that small issue, you said public interest. I think the word used there is of general public importance. What to you is the difference between a matter of public interest and general public importance, and how would you distinguish the two?
Public interest can be compartmentalized. You can dissect it, because you can have NGOs coming in the name of public interest, but they are serving their own sectional interests. General public importance is wider. It covers, as you read this issue, it seems to be affecting the general public, like BBI. If an issue is presented before the Supreme Court relating to BBI, having come all the way from the High Court to the Court of Appeal, it will be a matter of general public importance. So to me, public interest is narrower compared to general public importance.
And what is the test? What is the test in your view? How would you distinguish the two? Because that is where the meat of the Supreme Court jurisdiction is vis-a-vis the Court of Appeal. How would you distinguish the two?
The short answer to that will be, it will all depend on the issue itself and the objective interpretation of the court, because I cannot perceive an issue and say this is general public importance. For instance, if it's a nationwide issue which is the concern of the general public, like I'll give an example, like if an issue, somebody was to say Kenya should no longer borrow from the IMF or from whoever, and goes to the Constitutional Court, and an appeal is taken to the Court of Appeal, that is a matter of general public importance. That is an example.
Any cases that come to mind?
I'm giving because there isn't. I'm giving an example that.
I mean, because what I want to know is the test, because part of the complaint you will hear out there is that the Supreme Court came to solve all our problems, isn't it? But why do we have a Supreme Court yet it is not hearing our issues? So 164 has said no, we are not dealing with everything. We are dealing with issues of general public importance as opposed to public interest. So one of the things you will be dealing with on everyday basis is how do we distinguish these two streams? That this one, go home, it is public interest but not general public importance, and this one may be of general public importance but the public has no interest.
There is no one answer to that. I will lie to you to say this group of cases belong to general public importance, and this one, because it's initiated by lawyers or by an NGO, it's a matter of public interest. Okay. It will all depend. My answer is this: honestly, it will all depend on the problem itself.
Okay. There are many decisions of the Supreme Court on that. Next question, and just as I'm finalizing on this aspect, one of the issues that concerned me when you were starting, and this goes, you've talked about a backlog and dealing with backlog, and thank you for exposing some of the problems we face. One of the issues you said that which I caught is that you worked yourself to the extent of becoming a diabetic. Now my concern is this, room 17, you are holding 5 hats. What fear, should I fear that those 5 hats will cause you to aggravate your diabetes? And what is it you will do to prevent, to avoid this kind of situation?
Okay, I think the bigger problem is the induction. When you are inducted, that time you are not warned against overworking yourself, and that is a bigger problem. I think some of the committees came up with the issue that newly recruited staff should be inducted. I'll give you an example. On a Thursday when I had confirmation of grants, I would sit from 9 to 3 without even taking a break. I've learnt my way in the judiciary that you need to take a break after maybe 2 hours. And the many hats, these many hats will not come when I'm just seated in the office doing the work of many hats. You'll have to go out, interact, you have to come for a meeting and deliberate on issues, and so it's not an issue that one has to do this work whether you are diabetic or not, whether you are epileptic or not. Those are conditions which are there, but I've learned from the hard way how to handle these many hats. That time I think I was overworking myself, no exercise from the office, to go and sit and write judgments up to maybe midnight in the morning. You wake up by 5, you are definitely will be sick.
Thank you. And finally, I think in one of the papers today, and since this COVID started, the issue of domestic violence has gained a lot of prominence. What do you see is the role of the CJ dealing with the problem of domestic violence?
Okay, the domestic violence, I believe, is related to the family, not mainly husband and wife. Even children are affected by this violence. It's not a Chief Justice only problem, because those involved have to be arrested and prosecuted and the cases fast-tracked, so that if one is convicted, it can send messages to those who are involved. There are already cases in court, people chopped off their hands and convicted. So the role of the judiciary and also of the CJ will be to ensure that whoever is implicated in this is prosecuted. But I'll have another angle to this.
Let me just ask, is there any of the hats you're wearing that focuses on this particular issue?
Yes, there is the hat of being the head of judiciary, and the hat of National Administration, Council of Administration of Justice, where other sectors in the criminal justice or the justice systems are involved. It can be discussed there. The CUCs, that's where I was heading. Sometimes you can see prevalence of an aspect of criminal law, and you go out and educate the people. I remember we used to have so many outer talks in Kakamega in conjunction with the county government. Cases of forest people being charged with taking wood from the forest will go near the forest and talk to them. The implication, the cases will reduce. So if, as the chair of the National Council on Administration of Justice, we can rope in the prison, rope in the DPP, and sort of sensitize the public that domestic violence is becoming rampant, and we should know how to deal with it. I think the CJ has a role there to play.
And finally, in terms of case, that same issue, what do you think, the same issue of domestic violence, now we have the COVID situation, we have operations of the courts have been affected. What kind of interventions would you look towards enhancing access to justice in that particular sphere?
We have had COVID, the courts are working, those arrested are taken to court. I know the prisons have been a bit hesitant to take suspects up to open court. We have technology. So as the CJ, I will try as much as possible to ensure that it has worked. All what we can do is to enhance the technology. It has worked. A plea can be taken from the prison as one sits in court, and the prosecutor is in his office. So it's not that we will relax. We will ensure that technology takes over and these cases are heard.
Thank you, my lord. Thank you, Chair.
Thank you, Judge. We are going well. Judge, you can have a sip of water. It's 2 hours. I will now request Honorable Commissioner Machadi Ajeru to ask you some questions, and then after that you have Honorable Commissioner Evelyn Olwade to ask you further questions. Thank you.
Okay, thank you, Chair. My Lord, now let us start on this issue of jurisprudence and your legal philosophy. Now, I read this decision that you made on the Council of Imams and the Preachers of Kenya in Malindi, where you were clear that a child cannot be married off because that would not be in line with the Constitution. You extensively made reference to the Constitution. Now, my first question would be that why I took interest in it, the fact that you are a Muslim yourself. Now, how do you handle matters that where your Islamic faith may necessarily not agree with the strict legal provisions of the law? How do you balance that out as you are applying the law, even as maybe sometimes you may not, it may conflict between your religion and what the law states?
I think the Constitution is clear that there is no state religion, so that's the starting point. So when it comes to making decisions, they should be purely based on the law. I'm sure there are certain aspects of the law when they will be brought to you, and you can see that on the one hand the religion allows, on the other hand the law says this. That was one aspect, and even at the back of my mind I knew that those people who filed that case knew that I'm a Muslim, so let's go to this Muslim brother of ours and terminate this criminal case, because he will understand that from time immemorial, under the Islamic faith, a girl of 16 years can be married off. But my view is, first and foremost, you look at the law. And those who married off the 16-year-old girl knew that they are living in Kenya. In fact, I explained that when you are living in a country with the laws, the law comes first, then the religion will follow. It's not that you are being restricted. You know, there are those issues like a law is passed, don't pray. That will not be law, because it will be contrary to the Constitution. The Constitution acknowledges the freedom of conscience. So no law will be passed that don't go for your Friday prayer. But when now these are purely personal aspects of saying a girl of 16 years can be married, I am a Muslim, it's true. In other countries where they don't have certain laws like Kenya, where the marriageable age is 18, they exercise it. But I will go for the law, because if you go contrary to that, you will be setting a precedent that Muslims in Kenya can marry at 16, and I don't think that is the intention of the law.
Okay, thank you, Honorable Judge. Now, then that brings me to the second question of the issues of judicial activism, where there will always be a conflict between the three arms of government, each saying that this is my responsibility. And I want to specifically come now to the issue of legislature, because this is something that keeps arising, where the legislature will say that it's our responsibility to pass the laws, just like you've indicated. Then on the other hand, you find a party who comes and challenges that law, and now it becomes the responsibility of the judiciary to interpret. Now, oftentimes there is conflict that arises, that this judicial overreach. Now, what guides you as a judge, and what are your views regarding that? Because yes, the legislature sometimes will also overreach themselves in passing the law, but they'll say that we are the people's representatives, that's our responsibility. But again, now if the judge comes to a decision that seems to overturn that law that has been passed, again the legislature will say this judicial overreach. I don't know what are your views regarding it, and what guides you as a judge, and what to be your role as the leader of the judiciary if you are to become the Chief Justice in dealing with those aspects.
These are not gray areas. They have been with us, and the work of the judiciary is to interpret the laws as they are passed by the legislature. And the main focus here is the Constitution. The judiciary will pronounce itself that a certain aspect of the law is unconstitutional. There is, in my view, that is okay, because it's the duty of the judiciary. We can't say that there is the general presumption that all the law passed is in compliance with the Constitution. But when it's analyzed, it's found that it is not, and it is the duty of the judiciary to punch holes to the law which is unconstitutional. However, we have had courts declaring certain aspects of the law as unconstitutional, but they still remain in the laws. I think there is need to come up with an approach. I have also said in the judgment one of the judgments Commissioner Majanja referred to. One judge will say this is unconstitutional. Another judge says it's not, like in the aspect of Section 40 of the County Governments Act. So, what should the legislature say? Should they follow the one who says it's unconstitutional, or should they follow the one which says it is constitutional? So there is also need to come up with areas with the improvement on this declaration of unconstitutionality. It is true this is a conflict. It's not an overreach. I will not call it as an overreach. It's a responsibility, because the judiciary is there to interpret the law. But there is that need of finality, so that actually when we say this section of the law is unconstitutional, in my view, there should be an automatic picking of that declaration by another superior court, so that it can consistently be held to be so. So that I, as a single judge, does not say that a section of the law is unconstitutional. It's left like that. Parties refuse to comply with that. Yet, maybe on appeal, it would have been overturned. So there is, it's becoming a bit confusing, and also the Parliament might wish that why can't this aspect be cascaded to another court, so that there is that finality that actually this is unconstitutional. It's true, you can say there should be finality in litigation, but when it comes to declaring law which has been passed by over 200 legislators, I sit there as a single judge. It's true, I'm the expert in interpretation. I say so. Maybe three wise men would rule otherwise. There is need to manage this aspect.
Okay. Now, coming to that issue that you just mentioned, where you have different judges coming to different conclusions, or even sometimes, and this is something that I've seen as a practitioner, for instance, in an employment court, where you find a decision has been made by a court of appeal clarifying a position, but still the employment court goes ahead and goes contrary to it. Now, I wonder, as a Chief Justice, in as much as it is not your responsibility to interfere with the decisional independence of the judges, but for purpose of enhancing kind of uniformity, or where this certainty, as is being said time and again, I don't know what steps you take as the leader of the institution to guide that that process of creating certainty, where different judges are not making different decisions over the same issue, or Court of Appeal has pronounced itself, then you find judges are going against it, or Supreme Court has pronounced itself, then others are going against. I do not know what steps you take, clear steps.
Okay, thank you, Commissioner. As the head of the judiciary, because these things come to the limelight, they are not secret. We normally have the yearly colloquium where we discuss emerging jurisprudence. We invite one of us to discuss. So, first and foremost, to disobey what the Supreme Court has said, yet the law requires that all superior courts be bound by the decision of the Supreme Court, will be now to dwell on, cannot say impunity, but dwelling on something else. Equally, to disobey what the Court of Appeal has said as a High Court judge, and to say, these judges, let them say what they said, let me continue saying what I've been saying, would also be to ignore the issue of judicial precedents and the hierarchy of courts. Because why did this party appeal to the Court of Appeal? So to solve these problems, it needs first and foremost to bring together, like if we can have a colloquium of the Employment and Labor Relation Court, and you tell them that you are creating confusion in the jurisprudence relating to this aspect of the law, and we deliberate on it and tell them that the Court of Appeal has guided you, so can you follow what the Court of Appeal is saying? Because it's not a matter of, you can have your own personal views, but it is a requirement that you respect a higher court. So I would be engaging the individual courts and all the judicial officers, because the magistrates are ready to embrace what the High Court has said. Why can't the High Court and Court of Equal Status embrace what the Court of Appeal has said? And why can't the Court of Appeal embrace what the Supreme Court has said? So I would, we will now come, we can even have a catalogue of conflict areas. There are even conflicts in the Court of Appeal. I've seen, as I was in Meru, there is the issue of under the Wildlife Act, if you are attacked by a buffalo, that act provides for a system where you start from a committee at the district level, but that process is not working, so people are going directly to the court, and there is a decision by the Court of Appeal saying you should start from that lower court, lower tribunal or committee, and there is another decision saying you can go directly to court. So these are issues of conflict of application of the law, and they can only be harmonized. Maybe like if it was a 3-judge bench of the Court of Appeal, if another issue arises, I would discuss with the president of that court to have a 5-judge bench, which can be seen to be more balanced and more pronounced, and rectify the situation. So I do agree that those instances are there, and it is for the judiciary itself and not somebody from outside to sort this one out.
Now let us come now to your papers themselves, your qualifications. I saw you have an MBA. Now tell me, and there's a reason why that will come out from my subsequent questions. This qualification would be useful in the institution if you are to become the chief justice.
Okay, I will answer that from my personal perspective. I took that MBA 1 year after I joined the NSSF, and I could see that we are dealing with finances, we are dealing with HR, we are dealing with ICT, and I have come with a background of the law. You sit in an investment committee where people are talking, investing in shares, investing in real estate, and you are there. All what you can say is you are giving legal advice. So the MBA becomes handy when it comes to dealing with issues to do with HR. It becomes handy to understand, because as the CEO of the judiciary, you will be receiving a lot of data, a lot of information from PMMU. It helps when you have to analyze the data. Like if I receive the DCRT of Commissioner Majanja, what has he been doing for the last 1 month? MBA enables you to analyze his data, how many rulings, how many judgments, how many witnesses have been heard. That is the simplistic aspect of it. MBA also gives you decision-making processes and how to make your decision, analytical aspect of your work area. So it is a crisp-cutting. Even the issue of I've been asked, how will you bring together these judges and remove perception? Under the human resource management, things have to grind the way justice grinds slowly. You can accelerate, but if you are to move faster, you will break, because if you become dictatorial, people will rebel against you. So the tenets of leadership are there under MBA, and I think it is a worthy cause for we lawyers to take, so that you know how to deal with people, you know how to deal with financial situations. I know as lawyers we do accounting at the law school, but that is basic.
Okay. Now with that MBA, I want to come now to the real issues that that lawyers particularly have to encounter every single day in the judiciary. Let me start with the issue of automation, the digital platform that the judiciary is using. Now, I don't know what is your view regarding it, because whereas there's Zoom hearings, there could be Microsoft Teams hearings, and all that, but when it comes to interacting with the system, for many lawyers, it goes beyond that. There's the e-filing, for instance, which is difficult. There are always, every single day I can tell you that the complaints I receive are so many. I'm always, exchanging those complaints with the institution of the judiciary on behalf of lawyers. They can't even sometimes even print a receipt. They can't be able to file their documents. The system is down, and of course, the hearing is not just the hearing online, between the judge or magistrate and the lawyer. There's also the aspect of documentation, and it seems not to be working. So I do not know what is your experience regarding the complaints in that aspect, and what you do to truly, digitize the institution, and not to equate online hearings with actual digitization of the systems within the institution. What steps would you take, using your MBA, knowledge?
Okay, I've had the same challenges because as you sit in court, you can't hear the lawyer on the other side. I will not blame this on the ICT staff. ICT is an expensive affair. I've interacted with that department because I'm somebody who wants to know why is the appeal not being heard, why at 10 after we start from 9 the systems go down, and they also have their answers to that. First and foremost, I think they are saying our capacity, what do you call them, is still very small. There is need. When we were in Mombasa for a colloquium, we were taken through all this. They want to expand the capacity of the data center so that it can work, many users can punch in and it works. So that is a problem. Another problem is staffing. I've been told, and I've taken the personal initiative, that what we are using is homegrown. We didn't go to the market to buy a software which can handle our work. It has been developed from within by 4 developers. And these 4 developers, whenever there is the time down where there are difficulties, they have to be the same people who should go to firefight. They're saying they're not enough. And we need to invest in this so that we can have an expanded band. I think that's the word. The band is not big enough to accommodate many users at the same time. When every judge is there from 9 to midday, there is a lot of interruptions up and down. So the problem is known, and the ICT people are working on it, but there is need for the judiciary to recruit more ICT staff and expand the bandwidth. It's expensive because I've talked to them. They have that little knowledge. I can't say I'm an ICT expert, but they're saying even we are working at the mercy of international companies like Google, because when you have to go to Safaricom to allow you to use their bandwidth, you will be charged a lot of money. So that's why even the licenses, after every year, our licenses expire because we are using the ones given freely by companies like Google, so that we can minimize on cost. So there is need to deal with this problem of ICT, because it is, in fact, it has changed the work format. Mentions, why do you have to drive from city center to Milimani to mention a matter? It can be mentioned online. Appeal, an appeal where parties have filed submissions and they want to highlight, why do I need them in court? So there is that need so that the virtual hearings can be real and compared to physical hearings, mainly in those aspects of the law where we can easily say an appeal can be heard. It's 20 minutes each. I will hear you. I have your submissions, and the system should remain constant until each advocate completes his submissions. So going back to the NBA, when you do NBA, I think you also do the information management systems, and you don't become an ICT expert, but it exposes you to how ICT can be harnessed to deliver justice.
Yeah. Now, for you as a judge, and I'm sure you've also interacted with your colleagues, do you have that ease of access and use of the system? Say, like if you want to access and get documents that have been filed easily, is it, you know, is it a challenge, or is it something that you're doing very easily?
Okay, for now it's still a challenge because I would sit in court and an advocate filed an affidavit of service yesterday, and you peruse, it's not there. And the court assistant will tell you, I have gone through the system and it has not appeared. So there are delays. So it is still a challenge. It's not easy. I filed submissions, they were filed 3 days before, but those submissions have not appeared in the portal. Or a lawyer wants to pay for a plaint, but the system is not picking. So it's not me alone. Everybody is complaining. But this thing became abrupt. I can't blame the staff. It became, nobody knew COVID will come in. So we have now to accelerate the system. It seems we ran against our time and enabled the lawyers to work when it was not yet ripe for that. So I can't blame them. They are really improving. But we can say, so far, it has assisted.
Yeah, so if you became now the Chief Justice, what are the key steps that you take to resolve some of these issues that cannot wait for too long, you know, because we need to be up and running, because a complaint every single day regarding the user, the ability to interact with the system efficiently, where now what we thought is a solution is also becoming a problem in itself, without of course abandoning, because we can't go back. I don't know what steps you would take as the leader of the institution.
Okay, when you are asked to talk as the CJ, sometimes anyway, if I become the leader of this institution, ICT is already there. What is needed is to improve on it. So improving needs resources. And there are certain aspects. I think that we have a whole ministry of ICT. I don't know whether I've not been working from inside, but from the little information I have, is that the ICT department and the judiciary management is engaging the Ministry of ICT. There is what they are calling the Ajira program, which they're trying to work with, so that the proceedings, they are recorded, and the Ajira program, they are given to the ICT ministry, and produce the transcript. They have parameters so that you don't lose confidentiality. But to go back to this core issue of logging in of users and e-filing, it was launched very recently. We should not expect magic within this short time. So as the head of the judiciary, I would sit down with the ICT department, get down the requirements to improve on this. I know some of the requirements is that they are shortchanged. In fact, one of them told me that to procure an ICT thing takes a long time. The procurement process is very long, and the judiciary needs to ring-fence the money, the money which has been budgeted for ICT, because by the time the procurement comes through, this money has been used by other departments, because we are thin in resources. So they are saying it becomes a problem, and if you wait for next year, maybe that technology has changed. Now we have a new type of machine which has to be, the one you are buying has become obsolete or needs improvement. So as the head of the judiciary, maybe I will ensure that whatever is budgeted for ICT, because it's becoming an important enabler of justice, is used within the ICT. I would even rather put off the construction of a court and expand on what ICT can do, so that it's not becoming, as we said, it was to enable us access justice, but now it's limiting to some extent. We want to reach where we wanted to go.
Yeah, because as you said, there's a significant number of lawyers who feel that the system actually is now becoming an impediment to access to justice. Now, burden of proof, because it's one thing to say that you'd be able to do all that in terms of providing leadership in that. Now, what is it that in your experience, when you look back at your background, because again I've checked right from when you're an advocate to NSF and all that, what is it in your background would make us believe that you've acquired these skills where you can be able to ensure that you're able to oversee the implementation of an efficient digital platform that serves the institution and of course the public at large?
I believe I should restrict myself to digitization, not to the wider aspect of the leadership.
Yeah, the digitization.
Okay, from my background, when you are a practitioner, our times there wasn't a lot of digitization. You have your computer in the office and you use it to produce your pleadings and do your internal office management. I interacted with this ICT when I was at NSSF, and it's expensive. You have to buy systems which will enable each branch to log in and see the processes of the institution, working on the benefits of the retirees. Coming to the judiciary now, we have talked about ICT for long, to the extent that now it is becoming monotonous. ICT. The JTF, one of the pillars is ICT. They did their best, acquired, established the ICT department or directorate. SJT has come up with digitization as one of the pillars of SJT. So the totality, the burden of proof, which is the answer, is I know how ICT can improve the workplace. I know for sure it can. And the only solution to this is to talk to these people who are working on it. I remember at NSSF would spend millions, but when the instrument is bought, it doesn't work. You would go back to buy another one. So it can be an exercise in futility if you get it wrong. The beauty with the judiciary is it is homegrown, and but we need to buy certain aspect of these ICT instruments and cooperate with the ministry, and we will be there. I don't have to say that 100% when you take me, if you take me as the CJ, I will make sure that ICT will work in 100 days. You will be able to not to see these ups and downs. It boils down to the same thing. You have to make people agree that they are here to serve the wananchi, and they should do their best and improve on what is existing now.
Okay, I have three more questions. One, now you mentioned about the issue of backlog and sometimes delays in writing of judgments and all that, and I want to tie this to the issue of leadership generally. And you actually even said that the Chief Justice Emeritus did even write at one time a letter to all the judges telling them that, you know, you've to deliver judgments within this time. and many of them still didn't. Now, I'm just wondering, what is it that you do as a Chief Justice to make sure that when you do a communication, it is not in vain? It is a communication that will be followed through to, with a view to ensuring that those judgments are indeed delivered, and if they are not delivered, that there are also consequences. Because again, if it's just an idle threat or a communication that is no follow-up or there is no implementation in terms of ensuring it's it's indeed followed to the letter, it's of no value. Now, what is it that you do as a Chief Justice to ensure that when there's a communication, when there's a directive, alive also to the fact that you are dealing with people who have security of tenure, they have their rights, but at the end of the day, again, there's the delivery of justice expeditiously?
My long-held principle is that you should justify the salary you get. You cannot be in this institution idling around, doing the bare minimum, and expect to get the salary from the taxpayers. So when it comes to that, the CJ Emeritus was very emphatic on this. He didn't issue mere demands and went to sleep. He would even follow it up for those who have not complied. He would follow it up, and he will even be calling them. Have you complied with this? I remember the office of the DCJ, where the ombudsperson is currently entrenched, would make a demand that can you comply with the letter by the CJ. So we'll put everybody on his toes when it comes to this issue of delayed judgments, when it comes to this issue of backlog, because backlog creates perception of corruption. That is for sure. Even you, if you have a case in court for 10 years and it's not determined, you might think that you have to go and bribe your way at the registry for you to get a hearing date. Commissioner Warsame dealt with the delays even in getting hearing date. But I can say we have improved. When we used to practice by March, the diary for the year is closed. You wait for January. But now in many courts you can get hearing dates for July, you can get hearing dates for magistrate courts for August, even for June. So as the head of judiciary, it will not be a matter of standing on top of room 17 as commissioners referred it to, issuing demands that you have to comply and waiting for compliance, which is not forthcoming. I will be, maybe the main answer to this will be the PMMU, because that DCRT PMMU instrument can flash whoever is working and whoever is not working. The systems now can show how many judgments have you delivered, how many witnesses have you had this week. It can. So as the head of the judiciary, I will rely on this directorate that give me data for each and everybody, and it should be actual data, no raw data. I know sometimes you send the data and the station says you have given us the wrong information. Physically go there, count the files which the judge has delivered, judgments or rulings, count the backlog, and we are rated every year. They go around and assess what has been done. So I'll emphasize on that. And for those maybe who might be falling, you have a roundtable discussion with them. You are right, these are people with security of tenure, but security of tenure also calls upon responsibility. It's not a security of tenure in vain, whereby you come and say, I'm not doing anything, I'm not being supervised, I'm the presiding judge of the Nyeri court, I don't want anybody to ask me what I've done. You have to be responsible, and that is part of the code of conduct for the judiciary. You have to be responsible and deliver as expected.
You know, Honorable, my Lord, I'm asking this because these are some of the matters we are dealing with also at the JSC, where it has gone through that process you're indicating, but it reaches a point whereby the complaint has now come directly to JSC. It becomes a complaint. So I'm still wondering that beyond the round table discussions, how do you as the Chief Justice ensure that indeed that it doesn't reach a level where JSC now has to deal with it as a complaint when it could probably also be sorted out administratively?
Yeah, there are many ways we can deal. For instance, let's take an example maybe of a judicial officer who is performing below the average. A human resource will require that first and foremost you know his problems. Is it naturally an issue of laziness and refusal to work, or maybe this judicial officer has some social problems at home? Another issue is to discuss with the judicial officer for him to know or her to know that actually you are underperforming and you came here on the promise that you want this job because it's you who applied to get this job, and comparatively, because you are not working alone, there are 100 of you and the 5 of you seems to be working below average. I would also look at the aspect of maybe what is your specialty. Maybe you have problems dealing with the criminal law and you like to deal with family matters where the turnover you can sign grants and hear objection proceedings and refer matters to mediation. So it's an all-rounder, but the bottom line is we want to uplift this judicial officer to the same level as the others. And what do we do if it becomes impossible? Even with that stick, you are trying to propel the officer to those levels, but still you are not getting the results. I believe the question leads to that. What do you do? I think that's why we have the JSC here. The CJ does not have the mandate to send anybody home, but the law comes in and say you can be retired in public interest because now you cannot perform. You are sick. You have told us you are sick. Maybe you take early retirement. Maybe because it can be a disciplinary issue. Because disciplinary doesn't mean the code of conduct is that you have to work. The idea of the code of conduct is that you have to work. That's why within the certain parameters, and if you are not fulfilling your obligations, then when do you pay you? JSC is paying your salary and you are not working. I don't think it can be a hopeless case where we are saying we cannot deal with this officer. I think we can deal with those situation administratively, and if it is not working, we can escalate it to the JSC.
All right, thank you. Now, my final question. The key stakeholders in your understanding of the judiciary, if you could give me an indication of the 3 key stakeholders, and if possible in the order ranking in priority, and the reasons why you'd rank it that way, the stakeholders of the judiciary, you as the Chief Justice, that you would focus on in making sure that you satisfy them.
There are many, and to name 3 will just be to a tip in the ocean. But the key stakeholders is the public, because that's where we derive our authority from. So the members of the public are our main stakeholder, although this will encompass everybody. But as we sit as judiciary, we should know that we have been given this role by this public who are the taxpayers. So I will give that as the number 1. We are here to deliver justice to all, and all means the public. We have the judiciary itself has a stake in the judiciary, and by the judiciary I mean the staff, JSC. We are stakeholder by our own right, because we are here, we are working, we are earning. So the interest of the staff, the interest of the institution is also another component of being a stakeholder. The litigants who can come individually and through their appointed advocates, like the LSK, this is another stakeholder component, because it's a business also. It's a service industry. You serve the wananchi. They come to get justice from us. So the litigants are stakeholders. They want their cases to be heard, whether they have lawyers or not. They are stakeholders. We have the DPP is a stakeholder in the judiciary. He wants, when he charges somebody, his case, he wants it to be prosecuted. He's a stakeholder. The AG is a stakeholder on his own right. If the government has a complaint or has been sued, they want that case to be heard fairly, partially, and as quickly as possible. So the list is endless. The prisons are stakeholders. They want us to hear the criminal cases and finalize them, instead of having people put on the vehicles every day, brought to court, brought back to the prison. They are stakeholders. So the list is as long as I can say. The NGOs, they are stakeholders. They are people who are fighting for others' rights, as enshrined in the Constitution. The NGOs dealing with human rights, they are stakeholders in their own right. The business people. Why did we create the commercial court? The idea was to facilitate business disputes and hear them as fast as we can. But the commercial court has become just like any other civil court. Cases are taken there. They take as long as they can. So even that aspect of having a commercial court has to speedily hear these cases has been lost. So the businessmen involving banks, companies of whatever nature, they have a stake in the judiciary.
So how has your experience, your background experience, helped you in interacting with all these key stakeholders when you go back to when you became an advocate? And that's my last question, and I thank you and I wish you well.
As I've said, the lawyers are a stakeholder. So I was a stakeholder in the judiciary, and I could see the many problems. As I've said, during our time there was a call-over, monthly call-over. You go there, all of you in court 1, and you allocated only 2 cases that month out of your 100 cases in the high court. So my background knows that what the lawyer wants, whatever decision you make, whether he wins or not, he wants his case to be heard. So if it cannot also be heard, even hearing it is a problem, then that stakeholder has a problem. Another stakeholder I've interacted as a company secretary. If an institution has a case before the court, you as a company secretary, every time you go to the boardroom or the legal committee, they will ask you, how far has this case gone? If you give the same report today, after 4 months or 6 months, you go there, the case has been fixed for hearing. If you go there, it was adjourned to next year. So it defeats logic, and even it makes work impossible for some of these officers in the legal fraternity. Even the lawyer now, he can't get a hearing date. And if he gets it, the court is not sitting. So that experience gives me the background to know some of these pitfalls we may be having and how to fix them. So those are just but a few. Now, coming from within, I can see the numbers. Commissioner Warsame is right. Why is it that despite the increase of the numbers, still the work seems to be balancing? But the numbers of cases also have gone up. The statistics are there. Each year what is filed is more than what was filed last year. So my background gives me that that knowledge of what an advocate feels as a stakeholder when he is told that these cases have been removed from the cause list without any explanation. They have been removed, and you have been waiting for 2 months to get it heard, but a day before you are told it has been removed from the cause list. There are good reasons. The cause list is 40 cases, but how did we reach there if we have electronic fixing of cases? Why can't we cap it, and when it comes for hearing, it is heard? So I know what the stakeholders are suffering, and I know how much we have done to satisfy them. Thank you.
Thank you very much, Commissioner Jero and Honorable Judge. At this managed time, I would request Honorable Commissioner Orwade to tackle several areas, which is the conflict of interest, Commissioner Orwade, the corruption issues, and propriety and respect area together. Thank you.
Thank you very much. I don't intend to take a lot of time because a lot of the questions that I had have already been addressed. But just speaking on the last question you are responding to, my lord. On the issue of the experience that you've had, you're one of the very few judges who have had experience in the justice system being on the receiving end of the services that judiciary offers. It is often said that it is the wearer of the shoe who knows where the shoe pinches. You were once charged in an anti-corruption case and you were eventually acquitted. But I would like to hear from you how that experience has enriched you and what insights that maybe you have gained that will be of benefit to the judiciary being on the receiving end of the services that we give.
Thank you, Commissioner. There is one document I wish I had laid my hands on. This is the report of the vetting board. I had that report when it was now giving the findings for every judge, and what you're asking me is there in that report. When you go through the process, you can see that there are those who are coming to this judiciary not to have their cases heard, but just to cause delay and maybe to embarrass or to serve outer purposes. But the judiciary should have that focus. Whatever case is brought in is brought for a good purpose, and hear it as fast as you can. My personal experience is we were two initially, me and the CEO, and 2 lawyers were enjoined who were handling the transaction. So the lawyer's intention was to delay the case, and they have filed an application to stop the hearing of the criminal case. And I have my ruling with me here, where I had to go to the Court of Appeal and say, because the late Commissioner Camino had granted them the orders that the prosecution should stop, and I had to file an appeal because I was not involved in the application. My view was, can I be heard? Can the public know what I stole, what I took, so that this issue is settled? So thanks enough, the Court of Appeal agreed with me, and we went back, and the 2 of us were heard. And we, up to the last level, 35 witnesses, no case to answer. So this experience makes you know, like if you read that report of the vetting board, if an accused comes before you and raises his hand, hear him.
Just take your time, Honorable Judge.
It's good you have asked some of these questions. Okay, I know what people have to be prosecuted. That is the mandate of the DPP. But as you sit as a judicial officer, you should be able to sift out what has been brought for serving other purposes and what has been genuinely brought as a court case. And I'll give an example, like granting bail. I can't understand why a court will take a whole month to grant bail or deny bail. You'd rather even deny so that this party can go to another court. But if you take two weeks, the spirit of the Constitution is that nobody should stay indoors. Then I agree, there are those cases with compelling reasons. If we have people charged with terrorism, you can't just grant them bail. There are heinous offenses which are committed, you cannot grant bail. But sometimes I can't understand why somebody charged with a corruption offense is a whole governor. Can he run away? Surely. And if he will, are we not having any ways of bringing him back? And the case the bail application takes a whole month. Maybe the governor is in custody. That is, it's not that because a governor is maybe well paid and whatever. Even the simple cases, why should somebody charged with assault stay indoors for 1 week, yet the magistrate is grumbling with whether to grant or not to grant bail? So as you have said, it's the wearer of the shoe. I've gone through this process. I have to appreciate that mine cannot be said to be a bad example of the judiciary, because the case was heard within 1 year. Thanks to the magistrate, she was very industrious to hear us. It was a corruption case which the law allows to be heard on day-to-day basis. But those who bring you to court will develop cold feet, and that's why I was saying we have few magistrates in Nairobi hearing these cases, and they're overwhelmed. It's not that they are lazy, they're hard-working magistrates. But why can't the leadership of the judiciary decentralize these cases so that we know if you are charged with a corruption case, you are from coast. The idea is if you are from Mombasa, your supporters will come to Mombasa court and start singing, we take you to Lamu, or we take you to Garsen, and the case is heard as fast as... I'm sure that magistrate will be having that one single case with 40 witnesses. Within 1 year, that case can be heard. It's not that the system is bad, but there are ways of perfecting it. And to answer your question, maybe I'm taking longer than expected, but I have this experience. I know where the judiciary can improve. I know the judiciary is not the only player in this system, because if you are within, you can see this person has just been charged to facilitate maybe the riots, somebody was killed, and they had to arrest somebody and bring him to court so that the situation can calm down. So as a judicial officer, you should know why, or if maybe you release this person out of bond, you will be killed. So there should be that aspect of knowing what to do with a certain aspect of some of these cases. When I was practicing, the issue of delays, the judiciary, you can't get a hearing date. The judges were few. They were working, but still the numbers were overwhelming. So, Commissioner, I can look this institution from either ways. I can look at the judiciary from the eyes of a lawyer. I can look at this judiciary from the eyes of the stakeholder of business people or business institutions like NSSF, where you have cases which are never ending. They are never ending. Your lawyers are raising fee notes every time they mention cases. I can look at this institution from within, having stayed here for 12 good years.
Thank you very much, Judge, for that response. My next question will take us back to the Martin Charo case that you've been asked about from a different perspective, though. Often when a judicial officer is working or handling a case, you find yourself in a situation where the law kind of conflicts with your personal views or your personal sentiments on the subject at hand. I'm looking at the Martin Charo case. I've read the decision, and one gets the impression that in that judgment you're dealing with several aspects of our sexual offences law that have generated a lot of debate. The age of consent, the minimum sentences, the defense of reasonable belief that the victim is above 18 years old, and even the Romeo and Juliet clauses. And one gets the impression that your sentiments, your personal sentiments, may not be in consonance with what the law provides for. So what I want to hear from you, Judge, is what do you do in scenarios where you find what you believe as a person conflicts with what the law provides for?
Actually, it's not that the judgment is contrary to the law. That will be a narrow interpretation or looking into that judgment. As Commissioner Majanja has said, maybe the hue and cry is maybe the communication. That is another aspect of looking at it. So the several aspects at the age of consent, it's not that I'm advocating for the reduction of the age of consent. In another judgment, I tried to explain, I think even in that one, how other countries have the age of consent, some as low as 14. But the issue is not even the age of consent. The issue is, I'll go back to the question by acting CJ, the social aspect of the law. Is the law serving the people, and how do we interpret it? Because also it's an issue of interpretation. If I were to operate that when the ingredients of defilement, age, the action and identification, and go to prison, I don't think that is the duty of a judge. The issue is you have to analyze what transpired. So the age of consent to me is not an issue, but my issue is also the minimum sentences, because as a judicial officer, having seen an 18-year, until recently, an 18-year-old, a 17-year-old boy with a 17-year-old girl, the boy goes to prison. Until recently, when I think one of the judges said they all could not consent and acquitted them. So this minimum sentence to me is a problem, because it ties the hands of the judicial officers and it is contrary to the aspect of independence of the judiciary, because the judicial officer is the one who is hearing this case. Because compare the Martin Charo, assuming I was wrong and I was to convict, can you compare Martin Charo with somebody who violently pulls a young girl to the bush and defiles? Yet all of them gets the same sentence. In the case of Martin Charo, these are people who have been dating. Even they went to the parents' home and slept there for 3 days. Even the brothers knew where their sister was. So can you say because the law provides minimum sentence, everybody should suffer the same fate irrespective of the circumstances of the case. I don't think so. So the minimum sentence should, Murwatetu case has come up with the aspect of murder, but I can see it being applied across all other cases. Reasonable belief that the minor was...
allow me to interject, please, because I've been made aware of the time. What I wanted to get from you is in instances where you find your personal views are conflicting with the law. You've already given us your perspective concerning the minimum sentences. You've given us your perspective concerning the fact that the law does not necessarily take care of the scenarios that you're talking about, the scenario where someone has violently attacked a child and sexually violated them, or where a child is cooperating, which in my view covers the Romeo and Juliet scenario. So what I'm asking basically is, when you find that there's conflict between what you feel or what the beliefs you hold as a person and the law, how do you treat that scenario? Thank you, Judge.
Okay. I don't think by writing the judgment I was enhancing my personal feelings. There are no personal feelings there. All what I'm saying is the law should serve the society, and that normative aspect, positivism of applying the law the way it is, I'm not in favor of that. What I'm saying is the law should serve the public, and it's not that I'm imposing my personal views that it's my interpretation of the law. It might be taken that by interpreting the law it's skewed towards my personal views, but to me it's just my honest interpretation of the law that under section 8.5 and 8.6 a judicial officer should look at the circumstances of the case. The word circumstances is there in those provisions. Look at the circumstances of the case. Do they exhibit an aspect of defilement, or they exhibit something else? And since the law does not give you the leeway to say, although there was an aspect of, you can call it even defilement, but the circumstances are different, I'm imposing 2 years, people will say the law does not provide for 2 years, or are putting this person on probation, then you have to interpret it wholly and see this was not defilement.
Thank you very much, Judge. My next question is, do you think that the consequences of a decision should be of concern to a judge when a judge is handling a matter?
When you're handling a matter, you are dealing with a specific problem there and then. Definitely each judgment has consequences, but it all depends on how you are looking at these consequences. If you are too timid, I can sit there as a judge. Whatever appeal come, I dismiss because the magistrate did good work, and I will not be in the limelight. So, if you are consequences-oriented judicial officer, you have no place in this judiciary. The consequences should guide you to effect the law so that the society will be able to know what aspects of the law is. So consequences, you can look at them, but it's not that maybe people can say, Saidi wrote that judgment without taking into consideration that women might think that he is against them. No. One aspect of this role of a judicial officer, I don't know whether it's impartiality or propriety, is the capacity to be independent and make your decision as per the facts and as per your interpretation of the law. The consequences, whether they will be hue and cry, they can be cured by other people. If the matter go on appeal, let them even dress you down. But to me, this aspect of independence, of making your decision, it's inbuilt. In fact, I have no issue sleeping over a file for like a week. I don't know what else. If I read your file, I look at it. It's not that I hastily make a decision, but with the experience, you just make your decision. The consequences can be positive, they can be negative. But if you want to be popular, you are seated there, just sitting on the fence, not making decisions which may have negative impact on you, then I don't know. But to me, the negative consequences are also admissible. So it's true you can look at the consequences, but does it shape are you saying something which is contrary to the society? We can't sit here and say young girls and boys are not engaging in this thing. The COVID problem, we have seen many girls sitting for KCPE when they have just delivered. It's a social problem. So me, I'm not saying that I don't know the society. I know the society. And I'll give you an example. A lady appeared before me in Malindi with a kid. She's a witness. And she was 17. I looked at her, she looked younger. So I was wondering whether to do the voidaya or not. But I see she has a child. So I asked her, how old are you? She said, I'm 17. It was a murder case. I think a relative had been murdered. So how did you get the child? She told me, this is my second-born. When did she get the firstborn? So this is the practicality of the law. So people can sit and give you an unnecessary award, but this is the reality. Go there on the ground. You have seen it. You convict a 20-year-old boy. The 17-year-old girl is crying, where are you taking my husband? These are the problem of the society. Those are the consequences. Now, do you look at the law and say, go to jail, or do you look at this girl who will turn 18 next year and be free to get married? And maybe they have a child. What do you do with this child? Who will take care of the child? I can give as many examples. You taking care of time. In Marsabit, a young girl who was in Form 3, she was defiled by a boda. They had a child. The family knows. Even they got married. One day the father goes to the child, to the boda to ask for money for milk. The girl is in school. This boda is a young man, he's playing pool, and he tells him, Mzee ngoja nimalize hii game. This is his father-in-law. The Mzee gets annoyed, goes to take his daughter from school straight to DPP's office. He's charged and is convicted. He comes before you. 6 months down the line, the reality has dawned on them. The girl is not in school. The child is not getting support. As a judicial officer, they go to the DPP now to plead that can we reverse this thing? We didn't know it will go to this, because the girl was around 17 and a half. So we are dealing with the actual problems on the ground. We are not dealing with the law in abstract, that you see penetration, you see age, you convict. No. I can give you as many examples as possible. The law in practice.
Thank you, Judge. Your point is made, and the examples suffice. Maybe if I can ask you a last question, now that I've been told to cluster all my areas together, not everyone is good at everything. We all have our weaknesses. Can you identify one weakness that you have, Judge, and what you have done to try and correct it?
It's very difficult to criticize yourself, but we are human beings. We are not machines. When you are set, there you go until when you are put off. We all have our strong elements and weaknesses. I think some of the strong elements can be turned into weaknesses. Maybe one can say I'm too generous when it comes to sentencing. Having, as you have asked, having gone through the processes, and I've seen it myself. Wherever I go to a court, those in prison are very happy because they think they will get a moderate sentence from me. But I've been firm. If I look at your file and you did something not worthy of being in the public, I will deal with you. So there is that aspect of witness, of seeing somebody from a social aspect of life, that every person can be reformed. I remember when I was in Malindi, in my entire practice, I've sentenced only 2 people to death. Yet the law, even before Murwatetu came. So there is that aspect in me, believing that even the worst of a criminal can be reformed. I am not against the death penalty. It's a good sentence. At times it's worthy passing. So that can be one aspect of my weakness. Another weakness I can tell you is maybe it's a strong thing, but also another weakness. I tend to believe in what you are telling me for some time. I consider that whatever you tell me has some elements of truth, but later on I have to analyze. So I'm not a person where I can dismiss you. There are some situations where you have to dismiss somebody. The moment he opens his mouth, you know he's lying and you dismiss. But I have that weakness. I have to listen to you. So even if you are lying, you have taken the religious text, but you are lying, I will leave you to talk until the end. Although it's part of our work, but sometimes there are those who will cut you short, and then what happened, just to discourage you to know that you are not interested. Maybe it has taken me as a surprise. I didn't know that I will analyze myself. Maybe another weakness is overworking myself. I believe in finishing what comes, so that end up in making yourself sick. It is a weakness because one should program himself and see how to manage your time, but I've learned how to do that, how to manage your time, how to balance between work and life. I think I'm now up to task.
Thank you very much, Judge. That will be all for now.
Thank you very much, Commissioner Owade. Now I would request Commissioner Honorable Attorney General to ask both questions related to independence and also the relationship between the different arms of government. Thank you.
Thank you, Chair. My Lord, you touched on the aspect of judicial activism. If I may ask you this, just to tie up 1 or 2 loose ends. And I presume over the years you have formed your own thoughts and impressions on the subject. What would those thoughts be? And how do you see judicial activism shaping the future of the Supreme Court in this country?
Thank you, Commissioner. Judicial activism can be both subjective, objective. It depends on how we view it. At times the judiciary is being accused of encroaching on other spheres of other arms of government. With regard to the Court of Appeal, Supreme Court, maybe there is the view that it is taking taking jurisdiction which it doesn't have, in the process actively making itself a bigger and wider institution in form of jurisdiction. So in the eyes of the Supreme Court, I cannot say that there is no judicial activism, but in my own view is that at times that activism is necessary to solve a problem, because the activism is not generated within. It's the law, is the cases which are filed there, which needs interpretation, and in the process of interpretation, a court can be seen to have been doing judicial activism. But I don't think it's a wider aspect of what is happening in the courts. And I don't think we can say that the Kenyan courts are now instead of dispensing justice, exhibiting judicial activism to the detriment of their core mandate. So to answer you, Commissioner, as assuming I'm there in the Supreme Court, all what will be my concern will be to deal with the issue at hand within the parameters of the law, and not to be seen to be stepping on the toes of others in advancing judicial activism. I don't know whether I've answered you.
Thank you. But with your knowledge, my Lord, of the Supreme Court over the last 10 years, this elasticity that you're alluding to, in what instances, if you were Chief Justice and the head of that court, in what instances would you encourage your colleagues in that court to exercise this activism?
This can come in different forms. For instance, the interpretation of the Constitution, which is a core mandate. That court is supposed to interpret the Constitution to give it meaning and purpose. What did the Kenyans want when they came up with this interpretation? I think, for instance, the nullification of the presidential election, some may view it as judicial activism. But what are they supposed to do? Are cases taken there just to be dismissed? There are cases taken there to be heard and determined according to the views of the majority of that court. So if I'm to be there as the president of that court, first and foremost, as I've said, we have to look at the case at hand. Does it call for what should be our parameters in this problem? It's a constitutional interpretation, or it's a matter calling for general public interest? So if it's a matter of interpreting the Constitution, we will interpret the Constitution in line with the parameters of interpreting the Constitution, and if it is seen that it has exceeded the limits, I don't think I will say that if I go there, I will tell the judges not to interpret the Constitution in this form, but use this format which is a bit restricted, so that you are not seen to be activists. So it's something which can be viewed from different angles. The loser of a case will always accuse you and say, this is too much. The winner will applaud you and say, hallelujah, I've won. But, and also, you have to take into consideration that any judgment can be criticized, Anybody can have his own views about what you say as a court or as an individual. So we'll try to be, but that has been happening. Every judgment has been majority decision. I've not seen a tie amongst the judges in any matter. Maybe if it is there, I've not come across it. So, Commissioner, as the president of the court, will try to enhance that collegiality and trying to work within the parameters so that all of us can be seen to be going together. But what we will decide together as a court, if it is seen as judicial activism, then that's it.
Thank you very much, Judge. Now, moving on to another aspect you have touched on. You've mentioned the word independence, certainly more than twice or thrice. What is this independence, judicial independence? What can you tell us about it?
I think we can talk about judicial independence in many aspects. The two major aspects is the independence of the institution itself. There is that perception, as we have started from the beginning, the judiciary was viewed or perceived not to have been independent as a whole. As an institution, it was viewed as an arm of the executive. The Chief Justice was just appointed by the President. The judges were just appointed by the President. So the public generally expects the institution itself to be independent. So if judges are being appointed, Chief Justice is being appointed, there is no security of tenure, they can be fired, and the left, right, and center be told to do ABCD, the institution loses its independence. And it loses the trust of the wananchi. And that it is that trust which is the core bedrock of the institution. The second aspect is the independence of the individual judicial officer. This is one of the tenets of the Bangalore Principles or the Code of Conduct as we have it. Are you independent when you are making your decision? In my experience, for the last 12 years I've been here, the institutional independence has suffered more than the independence of the judicial officers. And I can categorically say, I don't think in my 12 years there has been any interference from anybody in making my decision. There has never been. So this individual independence, it can be perceived that judges are being coerced to write. No Chief Justice has ever, I speak for myself, called to say the executive wants this decision to go this way, or call me to confide that let us massage this case to go this way. So that aspect of independence, I can say, has been preserved. So if a judge feels that he is under pressure because of the newspapers, because you are sent a present that your judgment was the worst and what not, and you feel now you have to act in such a manner, then you are only curtailing your own independence, but nobody is telling you to decide in this way. So independence is in those two forms. You as a judicial officer, you should not only be seen to be independent, but you should also practice that independence through your writings. You should talk through your judgment that I'm making this judgment honestly, impartially, and independently without any pressure from whatever source, be it the executive, be it the legislative, be it a colleague, be it a litigant, be it a family member. I'm writing this judgment with my open mind, consciously knowing what I'm doing. So independence comes in those two forms, and it's an international aspect of the judiciary. It has not only to be seen to be independent, but it has to be independent. But the first aspect has several factors, because you are the judiciary, you don't have finances, you have to beg for the finances. There is no set parameters that you'll get this. You can even be allocated those funds and they are slashed. So are you independent? So those are the parameters of independence. You can be independent as an independent judge, but as an institution, that perception is still not there because of the workings of the entire system of government.
Thank you, my lord. Now you've summarized a few of the challenges. How would you address them? That perception of the absence of judicial independence in the institution. You now take office. How do you address those challenges you've just alluded to?
Thank you, Commissioner. These are challenges of the judiciary. The institution sometimes does not have the resources to do what it plans to do. What do you do as the Chief Justice? The only solution is you cannot say I will generate my own resources, or I will deal with this perception of independence.
I don't want to interrupt you, my lord, but with respect, you don't need resources. Earlier on in your answers regarding the judges who have not been sworn in, you said you would seek out the president. Yes? If, for instance, your funds are not facilitated, what would you do in practical terms as a Chief Justice?
Thank you. You have come in that you don't need resources in some of these problems. That's correct. Some of these problems calls upon your leadership style. Do you make noise and say the judiciary is being frustrated? Do you negotiate, but at the same time not to be seen to become subservient to another arm of government? So the solution for this is negotiation, talking to the other arms of government, trying to make them understand what's importance the judiciary, what role the judiciary plays. They know, but maybe because I don't know some of those the reasons, like giving this example, I don't know the reasons. So I don't need resources to go and ask why haven't these judges been sworn in. All what it needs is the effort, and it's not that I can say within a week I might get that audience. You don't know, because it needs that patience and negotiation. At the same time, at the back of your mind, taking into account that you have to be independent. And if a solution is brought in which compromises the independence of the judiciary in whatever form, you know how to handle it, because we cannot be an institution where you can say we are standing on top of Mount Everest alone, another institution is standing at Mount Kenya alone. We are serving the same Wanjiku, and the paramount issue is how do we serve the Wananchi. So to go back to your question, how am I going to sort out this issue of independence and the challenges of resources? I will negotiate. I'll go back to the drawing table, see how we went wrong, be told where the judiciary went wrong, either accept if actually we went wrong, or explain our position, and try to pull those who are affecting the workings of the judiciary into what ought to be, so, and make them understand also. Sometimes it's done because of lack of the nitty-gritty understanding of the institution, but when you are not going there to bow down and go down your knees and say no, you are going there to negotiate as an equal partner in this government.
Thank you. And how would you relate judicial independence to judicial accountability?
Judicial independence comes with accountability. We are there as independent judicial officers, as an independent institution, but we are accountable to the people. This runs through the whole aspects of our work. Are we delivering judgments? Are we hearing the cases? Are we serving, in short, are we serving the people? So accountability is another aspect of independence. You have to be accountable to whoever you are serving as an institution. A company is accountable to the shareholders. They want profits by the end of the year and dividends. The judiciary is accountable to the public. They want to be seen to be independently deciding their problems, not to be seen to be under pressure to serve them under pressure and give judgments or rulings which are contrary to the expectation of the litigants, just because you have been told to do ABCD and you do it. So the short aspect of the question is independence has to take into account accountability. You don't want to say, I'm independent, I've been given this amount of resources, I will spend it the way I want. You have to account for each and every penny so that there is proper utilization of resources in form of finances and in form of human resource.
Is accountability restricted just to finances? What mechanisms are there currently in place, in your view, to ensure that accountability by the judiciary and by the individual judges? And are they adequate, and in what form would you modify them if you became the Honorable the Chief Justice?
Accountability is not restricted to resources. It cut across the institution operations, resource-wise, work-wise. So it's not just a matter of accounting for what you are given, but accounting for what you are doing. The Chief Justice every year gives a State of the Judiciary address. That's another form of accountability. You are telling the wananchi what the judiciary has been doing, coming up with all sorts of data. These number of cases were filed, these ones were heard, these ones were determined. So that is one aspect of accounting to the wananchi. Another aspect of accountability is also to interact with the citizens, to show them that you are really serving them. The CUCs, it's another way of accounting to them. What problems do you have with this particular court? Can you come and tell us? We are trying to be accountable to you because we are serving you. So come through an open day, we tell you what we are doing, you pinpoint our problems through your representatives in the CUCs, tell us, is there any problem? I think that is a good example of accountability. We are trying to account that you appointed us to serve you, and here we are telling you that we have been doing ABC and ABC. So this is also another aspect of accountability. Another aspect is that one of the resources. We were given this much amount of money for development. It comes in that report also. We built this court. We established this mobile court. We spent resources like this. We paid out of these resources to the officers. So that is the institutional independence and accountability. As individual staff, how do you account? You account through your work. How many cases have you had? Are you really accountable to your employer, who comes in handy as the litigant and the public? So the totality of all is these judicial staff, are they working? You also become accountable, like walking into the registry in a court in Kakamega, and the staff just, yes, what is the problem? This case number, here is your file. That's accountability. You brought us your case.
My Lord, all those are in place as best as I know. Are there any specific ones that you yourself would wish to see introduced and working in the system?
What I can say, I would like to be introduced, first and foremost, as I've already said, I will build on what is already there. When it comes to accountability, is to enhance. It's true you have been delivering judgments, but the complaints are still there that we are not doing enough. I think that is the position, that we are not doing enough and backlog is piling. So when it comes to the core mandate, for us to be accountable is to enhance the delivery of justice. Enhancement of the judiciary, of the delivery of justice will be one of my core mandate, and an example that I'll try my level best to see that accountability comes in with the faster processing of cases and hearing them. Another aspect of my accountability is also to know the core competencies of what we have already. What we have is the ratio of judicial officer to the workload sufficient? Where is it not sufficient? Where can we improve? If we have enough magistrates, is there any need to employ more? If we don't, is there any need? And in what areas, which courts? So I will take, I can say if I were to start work, let's say by 1st of June, I will have to take an assessment of the institution. I know it, but you don't have the raw data of each and every aspect of this institution, like procurement. What have we procured? How do we procure? Are we accountable to, are there weaknesses? So your question is wide, and it cuts across PMMU. It's another aspect of how will I enhance accountability. It gives me the performance of each and every court. I will be able to see which court is working, which is doing the bare minimum. So enhance PMMU. Is it that the targets are high or the targets are low? So there are many aspects of visiting the courts personally as a leader to see what is happening there. Other aspects of accountability is to weed out those who are making the judiciary to be viewed negatively and improve on their performance, and if they cannot improve, you weed them out. I'm sorry, it's a wide question, and accountability is something which you can account money-wise, you can account work-wise, you can account operational-wise. Yes.
Thank you very much, Judge. Finally, you've spoken about the perception of corruption within the judiciary. Is it just a perception, Judge, or is there corruption in the judiciary? And what would you do to address that? What mechanism would you put in place so that the public's perception of corruption within the judiciary is raised?
Corruption in the judiciary, it's not only perception. There is the perception aspect and there is the reality. And the Wananchi are not pointing accusing fingers because they are the ones who come to us, they are the ones who see us operating and giving them the final product in form of judgments. And there are those who hear that this product was because of ABCD. So there is the aspect of perception. Perception comes in many ways. If I'm charged and it takes a month for me to be released on bond, there is that perception that maybe the judicial officer wants me to go and talk to him. Or if the case stays, or if I go to the registry to take a hearing date, I'm told the diary is closed. That litigant will have that perception that what do they want? And maybe he has had another advocate who was given a hearing date last week. So it's the perception crystallizes into reality. So I do agree, it's not only an issue of perception, it's an issue of reality. But can you stand and say, ABCD, you are corrupt? You can't. Because corruption is not practiced in the open. It's something which is within the society. Corruption is within the Kenyan society. So how the most important thing is to accelerate, as I've said, the handling of these cases, so that you reduce the waiting time of the litigants. That will erode both the perception and the reality. Because if I'm charged and within 6 months my case has been handled and finalized, both the loser might think that the other party has bribed the judicial officer to accelerate the case and the other cases pending. But if it becomes the norm that all cases suffer the same fate, and for instance, if the Court of Appeal is hearing cases on real time, you file it, it's heard next month, I think even the corruption, real or perceived, will be eroded, because that thinking that I have to bribe my weight for my case to be finalized will be diminished, because you know for sure this case will be dealt with within 3 or 4 months. I will have my judgment. Why do I have to look for the registry to give me a date? The date will be given automatically. So me as a Chief Justice, here I am. The judiciary has been accused to be corrupt. It's not perception. Surveys are done. People give the data. There are those even who say how much they give. So, as I've said, it's not something where you will come with a spray and you are told judicial officer ABCD is corrupt, you go call him to your office and lash him out and he comes out clean. You have to study the problems. They have been studied, but you have to come up with processes which will eliminate this, like the technology, e-filing. If it can be enhanced, no file will be hidden from the registry. You want your file, it's not in the registry, it's printed. Here is your file. Corruption has been eliminated. E-payment of court fees. You go there physically, you are supposed to pay 72,000 as the filing fees, but the judicial officer looks at you, he knows you are able to pay 72. He tells you to go and massage your pleading. That's what we have been dealing with. It's a special damage claim, but it's pleaded in paragraph 9, but in the prayers it's not there. The plaintiff prays that judgment be entered as per paragraph 9. I've been here. When you go to paragraph 9, he is demanding 10 million, but he has paid 6,000. The judicial officer there has told him, if you give me 10,000, I will reduce it. So this is the corruption. How do you do it? Bring your pleadings, pay online. It reduces that personal contact. So if you entrench that, another aspect of corruption which has been seen, here I am, I paid my bond when I was being charged, and I've lived here. For you to get back your bond payment, it can take ages. If it is done electronically, and if there are systems where the judicial officer is told, if you are saying the security in form of a title, not necessarily money, should be released to the surety, but this has to be done within 7 days. Those are the new approaches which we can introduce, and the magistrate will mention the matter after 2 weeks to confirm that somebody signed for the release of his security. Well and good. Those are practicalities, so that this person who is waiting for his title to go and apply for a loan can know that within 1 week the case was finalized and I was given my title deed. So corruption has so many causes.
Thank you. Thank you very much, my lord, and I'm much obliged for answering the questions.
Thank you very much, Honorable AG and the judge. Honorable Judge, now we are coming to a very critical area of finances and human resource, and I would request Honorable Commissioner Nishohi to please go ahead and ask questions on that area.
Thank you, Chair. Thank you, Judge. I will be brief, but before I go to the issues, you did raise an issue earlier on about laziness performance. Public service is about increasing productivity, and I wish to refer you to a civil appeal case number 138 of 2013 in High Court case in Kakamega. That case moved from Bungoma, went to Busia, back to Kakamega, back to Busia, and the case was handled by 6 judicial officers and 1 honorable judge. In fact, referred that case as a sad file, sad case. Eventually, you took up the matter, and you got a phone call from Nairobi, and you had the case. My question is, as a Chief Justice, a case that takes 5 honorable judges just to finalize, how would you regard that in terms of efficiency, productivity, specifically for this complainant in Kakamega in 2013, where you did preside over the matter? Just share your thoughts about it.
I would say that that is inefficiency, but maybe since I don't know the parties and what the nitty-gritties, maybe it may not also be important. But if the judge in Bungoma recuses himself, there is nothing you can do. It has to go to another judge. And by then, in 2013, I think we had recruited judges in 2011. The numbers had tried to go up, but Busia, Kakamega, Bungoma were single judge. In fact, there was no judge in Busia. It used to be the judge in Bungoma going to Busia. But by 2013, there was a judge in Busia. So that's those are the problems of the judiciary. That litigant will not say that the judiciary is working. My case, remember, if he has to go to Busia, it's cost. Maybe it's from Bungoma. If he has to Kakamega, it's a cost on him to travel, to pay the lawyer for traveling to Kakamega or Busia. So this, depending on the circumstances, I don't know whether in Bungoma he could not be heard because the judge recused himself. I don't know whether in Busia.
Honorable Judge,
Yes.
the case is about a petition of a ward representative. The apparent was Nathan Obwana. And the case originated from Bungoma. The judge declined to hear it, transferred the case to Kakamega, on to Busia. The judge in Busia recused himself. The file went back to it, and in fact at the point where even the judge himself, the Honorable Reddy, was much concerned. But eventually it landed in your office as a judge in Kakamega. My point is, did you have to wait until you get a phone call for you to make a judgment whether you're going to hear the matter or not?
No, the file is alive, and I was answering Justice Majanja, Commissioner Majanja, on the issue of jurisprudence. If I was given time, I would have picked it as one of my good judgments.
Okay.
Why did the judge in Bungoma, this matter was involving an MC elections. The magistrate had nullified the election, and it was a robust petition. The judge in Bungoma, after hearing those other election petitions, I don't know whether it was my sister Muchemi, decided that she could not hear it. I think it was interrelated with the other aspects of the petitions she had had. So she referred it to Busia. I vividly remember, by that time I think Judge Tuyoto was in Busia. But the law firm which was handling the petition, I think either he was a partner or he had dealt with it. So in good faith, the judge recused himself. And remember, these are petition cases. You don't call for the file, or it doesn't land on your desk and you hear it. You have to be appointed to hear an election petition file. So by the time it had done all those rounds, it landed in my desk. And I think there were guidelines then, because this is an appeal. It doesn't come to you automatically. You have to seek guidance from Nairobi. Can I hear this petition from Bungoma involving an MC election? I dealt with it. I had to be firm because there was an application for my recusal. I remember the respondent who had won before the magistrate court. The advocate is a lady, and as we gave directions. She was refusing to comply with those directions. I was firm. She applied for me to recuse myself. There is a ruling in the file, and I think it's the ruling which the Supreme Court even picked some paragraphs on the issue of recusal and bias, because she said so. It took some time, but I think in relation to that file, the complaint is not well placed, because every judge who handled it had his or her own reason of recusing. When it came to me, I decided this will be forum shopping, let me hear it, and I remember I overturned the decision of the magistrate and upheld the election.
Okay, Judge, that's enough. Let's go now to my line. This is about resources. Earlier on, you talked about lack of resources, inadequate funding for judiciary. If you get this position as chairperson of the commission, one of the key issues is to ensure that you have adequate funds for us to be able to operate. I want you to look at yourself as a chairperson and share with the commission 2 things strategic that you will be able to use or operate or institute to ensure that we get adequate funds, either from GOK or from other sources, as the chairperson of the commission?
Thank you, Commissioner, because without resources, your operations are grounded. And the resources, as you correctly put it, are from two sources. The first source is the exchequer. This is an institution which needs funds from the exchequer. And the way it is, the position now, the budgeting process, here you are, the judiciary comes with it is slashed to 16. That 16 is further slashed to the bare minimum. I'm not saying that I will have that quick fix, so that if I come in within no time, the resources are pouring here. There is money for everything. We also have to understand that the economy, of where the economy is, we have to understand we work in an economy which has been subdued by several other factors. So, as the chair of JSC, that's where the question is. What will you do?
Yes. One.
The responsibility of the chair is to ensure that you interact with these other institutions and negotiate for resources. You can negotiate but still not be given. You can negotiate, you can be promised. You can be promised will enhance the resources. But I will give an example. During the tenure of Justice Mutunga, the resources, although strained, but they were able to do many things, like the construction of the courts which we are seeing from the exchequer. I think it is his leadership which enabled him to manage to get these resources. And I will follow the same principles.
Okay.
Negotiate with the government, talk to them, make them know where you can be seen to be demanding, but show that actually you need these resources. And also on our part, you know, if you go with a budget of 20 billion, 10 billion is infrastructure, and you are not able to show that you will absorb the 10 billion within a financial year, that causes problem. That's why you give them the discretion to slash it. So I will have to come with a procedure whereby we go for what we can absorb, and maybe give a certain parameter of what if it is slashed.
Okay.
If we ask for this, so that is one from the exchequer. From the
let's stay the exchequer, and I want us to break it down. You talked about you negotiate. I want us to be more specific within the arms of government. And I said you are the chair of the commission. You are the head of an arm of government. So I want to see those negotiations with whom, what level, and the frequency of those negotiations as the chairperson of the commission.
First and foremost, we have to understand the budgeting process. This is a financial year coming, maybe for now, if I were to come in May, already the budget for the judiciary has been taken to the treasury. So whom do you negotiate with? That's the question. Which departments? There are those people who deal with the budget. The first point of call is the treasury. That's where the money is budgeted. Does the treasury know your needs? Does the treasury appreciate?
Okay, the treasury.
Yeah, so we have to sit down with the leaders of the treasury, be it the cabinet secretary, the permanent secretary. So that's one. Going to parliament, there are two aspects of committees there. There is the committee which deals with judicial issues. There is the committee which deals with finance, budgeting. I remember I sat here and we had the chair, Honorable Kanini Kega, coming here to talk about our budget. So there are two, apart from the entire parliament, You can negotiate with the committees when you go there to negotiate your budget and make them understand how and why you need each and every penny.
Okay.
You can negotiate with the leader of parliament, because that's where ultimately the decision is made. Apart from the committees, it doesn't take away the independence of the judiciary to sit with the Speaker of Parliament and try to explain to him what the judiciary is doing. And if you can get this amount of money, you'll be able to do much. Another point of call, this budget is taken to the cabinet. It's taken there. It's analyzed by the cabinet. You would have talked to the treasury. But the president is also there. He knows the priorities. As he sits there, he knows how many roads he wants to build, how many infrastructure projects. So if it comes to deducting, because by the end of the day, that it's a budget. The KRA may not develop or produce what has been budgeted. So when instances come to slash it, if you have the goodwill of all other arms of government, it will be ring-fenced, and that decision can come. Don't touch the judiciary. It all depends on how you have talked to them. We have talked of the Constitution providing for the judiciary fund, which is there. It has not been put into practice. It's another way of ring-fencing whatever is allocated to the judiciary, so that if the resources are given, they cannot be taken back.
Okay, Judge. Okay, Judge. You've talked about the judiciary fund, and I want us to stay focused as the chairperson of the commission. As the chairperson of the commission, and not the accounting officer. You are the chairperson of the commission. We have that fund. Up to now, it's not yet in operation. If you are to get this position as the chair of the commission, what doors do you go knocking to ensure that the fund is in operation? Specific doors that you do knock.
The short answer is that I'll knock the same doors. Why is it not operating? Because there is that feeling that the moment you open it up, maybe the finances may not be sufficient, or there are other reasons for not opening up. So you knock the same doors, go to the treasury. What am I required? The legislation is there. The judiciary fund regulations are there. Who is supposed to bring them into effect, and what are the consequences? The funds are definitely there, because allocation has been made to the judiciary, even if they are not sufficient. So I will knock the same doors and try to convince the the legal committee. Can we bring this fund into operation? The head of parliament, you pass this legislation. Why is it not being operationalized? The president, can we have our own fund?
Okay.
Yes.
Okay. Seated here this afternoon, the financial year is coming to an end in 3 months or so. Do you have an idea the budget of judiciary, the total budget for this financial year? Being an insider?
You don't want to give an exact answer, but I've interacted with some people from the judiciary, and the emoluments take about 9 billion, so that one is part of the budget. Administrative costs take in excess of 4 billion. So my perception, what I've heard, I don't want to say this is the budget. I think it's in the region of 16-17 billion.
16-17 million.
Billion.
Oh, that's good enough.
Yeah.
Finally, on financial matters, you are the chair of the commission. Financial management, financial practices are governed by various statutes. What kind of reports would you expect from your accounting officer in the course of the financial year? bearing in mind they are governed by law, what kind of reports would you expect to get from your accounting officer as the chairperson of the commission? Because at the end of the day, the buck stops with your office as the head and the chairperson of the commission. Four kind of reports that you'll be able to expect from that office.
Because the accounting officer is the CRJ, who is the accounting officer, and even if the judiciary fund is established, the office of the CRJ will be the one dealing with that fund. So by the end of the year, we must have a report on income and expenditure reports from the CRJ's office, which will tell us how much was paid and how much was spent. And that office will have captured the financial reports from all the other directorates, both in the administrative arm, and that office will have the financial position or report from the judicial arm, which is how many judges are there, how many vehicles we bought, how did we spend the money. So you are saying they are statutory provided. There is the Financial Management Act of 2012. I believe the report will be a judiciary report, a single report. Procurement will give its report to the CRJ. ICT will give its report, and these reports will be done maybe cumulatively every quarterly. We want to know, because the money is released to the outer stations quarterly, how much have been sent there, how it has been spent, because around May each court is told to wind up its reports, and all of them are sent to the office of the CRJ to compile this main report, which is part and parcel of the judiciary accounting system.
Maybe to wind up on financial matters, if you are as the chair of the commission, I'd be interested to know how your office as a chair will relate to the office of the secretary. You have had some experience in NSF as a company secretary. How is your functional relationship between the office of the chair and the secretary in terms of the operation of the commission?
I don't think there will be any problem, not because I've known the current CRJ for the last 20 years plus, but it all depends on your leadership style. I know the background is there have been problems between the office of the CJ and the office of the CRJ. You know, it comes in many forms. If you as the chair, you want to know how the tenders are being done and who gets the tenders, you'll have the problem. And I can tell you for sure, my experience at NSSF has widened me so much. There we deal with procurement, you deal with investment, you deal with all the sources. But the bottom line which comes into your mind, and you are told, the money is not yours. That's the most important thing when you are there. You see billions going to buy shares, you don't have to know which agent is given the money to purchase those shares. So the accounting officer is there. You sit down with that CRJ office. Here we are. How much do we, administration wise and salaries, those ones are capped. It's there. There is nothing you can do. So the only problem come in when it comes to the development expenditure. You as the chair, you have to guide. There is a court coming up in this and this place. We have been allocated funds. Can you implement? Because they are the ones who are, the directorates are under that office. This is the administration wing. So you have to be the leader who guides so that you absorb those funds, but at the same time leave that office to do its work.
Looking at the commission from where you sit or where you stand, would you share with us just one weakness, if any, that you see in the commission in terms of the structure, organization-wise, administratively, that you would address as you come in? Just one.
The structure is provided by the law, so I don't want to fault the law. And I don't
You
think...
are off the record?
It's on, I don't know what's happening. So the structure, I believe, I'm on record. The structure is governed by the law. So for me now to criticize the structure and say I wish the AG was not a member of this GSC will be to introduce extraneous things. So I think the structure is a representative and it represents all of us. Weakness, you know, when you talk of weakness, you can talk of many things. We are out there. For instance, judges are complaining that most of the time they are being called to JSC to answer things which could be done administratively. Is that a weakness, or is that part of the structural weaknesses? Maybe that will be a problem with the leadership. How, like I am from within, judges are complaining how comes within 4 years we have 3 or 4 judges who have gone through the tribunal processes. How? And in the history of the judiciary, how many have gone through that? So if you compare the last few years, it could be accountability, and now Kenyans are becoming wise to complain, but the structure and of the JSC in processing these complaints, it's being blamed by the judicial officers.
Okay. Let's just stay on with the chair of the commission, and I want you to address us on the question of diversity. You are talking about the population of judiciary, as we see it here, from 2013 to 2019, the total staff was over 5,000. That is the staff. The judicial officers, I'm sure they were also quite high. If you get this position as the chairperson of the commission, how will you ensure that diversity in terms of the staff recruitment, promotions, what kind of measures will you put in place to ensure that you comply with Article 232 of the Constitution in terms of diversity in the staff?
Okay, this is a broad aspect, and it's provided for in the law that when you are doing recruitment, you have to look at all the aspects of the nation so that the institution represents the face of Kenya. We have 5,000 staff. You cannot say this county should stop recruiting, we should stop recruiting staff from a particular county, even if the applicant has the necessary qualifications. But we will have to come up with a policy of first and foremost assessing which region is understaffed proportionally. There is that proportionally. You can have Marsabit County having 10 staff in the judiciary. You prorate it with other population, and if you see that these people are understaffed or underrepresented, then the next recruitment should take that into account, because we are not saying that we want equal representation from each county. No. What we are saying is at least there should be that diversity. I will give you an example. If you go to Kwale Court, you will not get a Digo interpreter there. I've been there. And yet the big population are Digos. So you'll get a Duruma interpreting Digo. So those are the problems.
Okay. Finally, Madam Chair, for me, it's about communication and engagement. with the other arms of government. There is something that is called strategic engagement with your key stakeholders or people that have to influence what you do. As the chairperson of the commission and also head of judiciary, do you see any place for strategic engagement, both formal and informal? And if so, how will you promote that?
Commissioner Mochari asked me about my MBM, and one of my topics or unit is strategic management. So you have to have strategy of engaging the other arms of government so that things can move. And in my own view, that does not erode the independence of the judiciary, because we have to talk to each other. So as the head of the judiciary, you don't want to be seen every day knocking the doors. You will become irrelevant. But whenever you have the opportunity to present your case or to explain, you go there with the facts and the statistics. So there will be the formal appointment. You go there, you meet the president. I believe the president also would like to meet the judiciary, because it's also, if the judiciary is not working, businessmen, money is held in the courts. He is also feeling it. So he would also want to see the problems of the judiciary. So the strategic engagement will entail talking to each arm of the government. If there is legislation which is to be passed in favor of the judiciary, strategically talk to those involved in passing the legislation, be it even individual MPs. Talk to them. I'll talk to them. I come from a constituency. I have 4 MPs from the constituency. I've been to Marsabit. I've been to Kakamega. So I know some of those MPs, they keep on changing. And doesn't mean that when you go there, you talk to them, you are going too low. You know, there is that aspect of thinking that this is our budget, let the money be brought, let them give us as per the budget. No, it doesn't work that way. You have also to engage. Engagement, strategic engagement, I would say.
Finally, Madam Chair, there is this, we have our GTI. I'm sure you are familiar with GTI. We have a population of 5,000 staff and also judicial officers. If you are to get this position, what kind of things we need to introduce in GTI to make sure that they respond to the needs of the staff and the judicial officers? What new things will you be able to introduce in that institute?
It's true, training 5,000 staff, it's a tall order, but all these other organizations like banks, believe Equity has more or less numbers of staff like the judiciary, they are trained. So I will have to come up with a strategy, first and foremost, of having compartments of the category of staff. If these are court assistants, how many do we have countrywide with that position of court assistant? If these are secretaries, how many do we have, and what are the training needs of these secretaries? If these are researchers, how many do we have, and what is the training need? We cannot train all of them at once, but we need to have that strategy whereby I've seen opportunities come for training. Somebody was trained last year, he is also trained this year. Somebody who joined the judiciary for the last 6 years has never gone for any training. So there is that need of giving an opportunity for each and every staff, first and foremost, to be trained, and to be trained on the same thing. If it's a training for secretaries, for example, and we have like 400 of them, we can divide them into number of days, as the colloquium for magistrates is divided into 2, and they all undergo the the process of training. If it is for judges, we have a formula. The JT has been coming up with the topics, and we pick which one you want to be trained on. But to be specific, I'll have to come up with a formula of ensuring that each staff gets the opportunity to be trained, because you can't be doing the same thing. You don't know whether you are doing it correctly for the last 5 years, and yet you don't, you are not engaged in training.
Okay. Thank you, Chair. Thank you, Judge.
Thank you, Commissioner Gishohi. Honorable Judge, your time is coming to an end. So I will request the Honorable Commissioner Koskei to combine your areas and go ahead and ask. Thank you.
Thank you, Chair. Good afternoon, Judge. I'll be very brief because most of my questions have been asked, so I'll be making a follow-up questions. And I would like you to be very specific in this. Looking at judiciary now as it is, are there areas that to you think can be run differently, perhaps to enhance efficiency and effectiveness? And what reforms? And you mentioned 2-3 in specific areas in order of priority will you introduce immediately when you take up the responsibility of Chief Justice? Briefly.
Okay, briefly, of concern is the service to the Mwananchi, and which we can do, as I was talking, is handling the appeals. I think I will deal with them differently.
Yes.
I will have to engage the Commission to see if there are weaknesses in the area of typing of the proceedings. A file takes time to be taken to the Court of Appeal from the High Court. In fact, there is that tug of war. Who should prepare the record of appeal, the High Court or the Court of Appeal? So the Court of Appeal is waiting for the record. The notice of appeal has been filed, and the file is lying idle. The proceedings have been typed. So, or the High Court is waiting for the record. So I think my quick gaze will be to deal with the appeals. Why? An appeal means that the litigant is already tired. He has undergone the hearing before a magistrate or before a judge, and yet the case is continuing. So why can't you bring it to an end? So that will be something which I can do differently.
Yes. Number two?
Number two is these transfers. There is a policy, but it appears that they are being done haphazard. They are being done haphazard. And actually, you might take it as a simple thing, go to this court, I've transferred you. But deep down, that judicial officer, you have demoralized him. I will come up with a policy. Let us have the priority of each and every judge. You are working in Nairobi. What will be your what do you think you should be sent next? So if I can have a list of all the judicial officers, magistrates, sometimes a judge is sent to a station where he or she was a magistrate.
Yes.
Had she been consulted, she would have said that before I became a judge, I was a magistrate in Kakamega. So I will be able to know that this judge for the next 15 years should never step in Kakamega. So
yes.
If we can have that policy, it's not that whatever everybody will pick will be the Bible, but at least it gives you an insight that look, you said you can work in Nakuru, and your third option is Kitale. I'm not giving you the second option. I'm taking you to Kitale. I'm bypassing this. Why are we doing this? These judicial officers are human beings also. They have their own family problems.
Very well, very well. Give us a third one.
Okay, a third one that
let it be management now, side, not judicial.
Okay, management side. I've seen a problem when it comes to this department dealing with the building. I was in Marsabit. The court station is not built, but these staff will come 3 times in a quarter, yet there is no construction going on. And the end result is that per diem is being paid. There is a clerks of work in Isiolo who can come and see if there is any damage to the structure and report. So I will have to deal with these management issues so that the construction of the courts does not become an avenue for people to be dotting around the country in the name of inspecting the courts, yet there is nothing going on.
So what do you think is the problem? Because that was my question, that you had mentioned earlier that you are wondering why you plant a court in Isiolo and leave Meru, that is very busy, or do Kwale and leave Mombasa. What do you think is the problem? What is the problem here? And how will you bring in strategic interventions to cure this problem?
In fact, those who made the decision, it's not that they were influenced by anything. I don't think anybody can say he was influenced to take a court to Kwale instead of Mombasa because I think they gave the list to the World Bank and the World Bank gave the okay. But how do you tackle the problem? I think you have to understand, as an insider, I know where a court is needed and to what extent. For instance, you have very huge magistrate courts. Hamisi is a story building. Where Madam Commissioner was a story building, although a smaller one. But you go to a high court in Kakamega, which was just an old court. So it's to know, first and foremost, I have to know. I can't say that I know each and everything, but you have to know the priorities. Yes. And if it's a government project, you have the leeway to say, build it here. This is the priority area. So to come back to the question is that is a weakness in the judiciary. We are happy to say there is this court in Engineer. It's a big court, but you go to Lamu, there is no high court.
So what are specific interventions that you will do? You've told us that, to me I interpret like you are saying there is no proper planning. When you come in June as a CJ, what are you going to put in place? Because it is not the building in Sholo or Kwale, but how does it, what is the decision-making process? What will you do differently to ensure that all these things are done and they are completed in time and there are no time overruns or cost overruns?
So my strategy, I believe that's what Commissioner you like to see differently. You start with mapping.
Yes.
You map the whole country. The stations with high courts and the nature of the court itself. Is it sufficient? Once you have mapped, and also the volume. As I say, you don't want to take a big structure and yet cases are trickling in, and yet there are places where they are busy and there is no facility. So I'll start with mapping in the key strategic areas where we need a court. Mm-hmm. So if a donor comes and say I want to build a court, instead of having a very voluminous court in Turkana, and yet I want to have maybe a court of appeal in Kitale or Eldoret, there is the Eldoret court up to now, there is a problem in Eldoret. In fact, the solo one, had it been built in Eldoret, would have been good, proper planning. So you are right, the planning is not proper. And it's not that people are being induced to go there, but it's just that aspect of you as the leader, knowing that between this station and that station, where are these resources required more? Because a court is resources, infrastructure. So you take it where the need is real. Although to some extent you can say there are some areas which are marginalized, which are not benefited from the resources. You can do that. So I'll start with mapping the area. not only physical infrastructure as well as the volume of the cases, and see how to diversify and place the resources effectively.
Thank you very much. My second question is, let us go now out global. Current affairs, perhaps issues international. There is this pandemic that has come in a big way, in fact creating havoc across the world, to the extent now that it has become even a diplomatic row, and to the extent now that there are a lot of tension across the world, that even United Nations Security Council passed a resolution to call for a global a ceasefire, because countries are almost fighting as a result of this pandemic. Could you please tell us briefly 2, 3, 4 diplomatic tensions across the world that has arisen as a result of COVID-19?
Thank you, Commissioner. You know, now we are dealing with globalization. The world has become a small marketplace. We have COVID. The developed world is developing their own ways of dealing with it through the vaccines. Nationalism is coming in, which is taking away globalization. We said we are globalized. If I need a vaccine from America, I should get it. But they will tell you, wait first until we vaccinate our own citizens. So this is a pandemic, and everybody is justified to use all manner of tactics to deal with the problem. I've seen the head of World Health Organization saying that this nationalization of the vaccine is causing problems because it's like it's ours, and we don't want to give it out until we are satisfied that we have reduced our numbers. So this is a problem.
Yes.
And it's my views, because I don't think the CJ of Kenya can sort out these problems. Even the Minister for Health cannot. But my view would be to follow the World Health Organization instructions, the Ministry of Health instructions. Wear your mask to minimize the risk. You sanitize, you keep distance, and it is a problem because economies are shrinking instead of expanding. There is the tug of war. You can see Kenya has withdrawn the Kenya Airways from going to the UK. America has given guidelines that don't go to Kenya because of ABCD. We are not the only ones affected. Other countries are in the red list. So now it is turning to we as Kenyans against any other country. We have had our own rift with our neighbors who didn't believe that there was COVID. So, Commissioner, it's not a closed answer question. It's
very well. You have answered. You have answered very well. My final question is on the role of the CJ. You know, as you are coming into that office, I hope you are aware that you will be diplomat number 1 in judiciary. You will be also fundraiser number 1, and you even mentioned William Butunga, who, when he was around here, you even stated that there was money, and you were wondering why we don't have money now. It was because of his fundraising skills. Could you tell us, number 1, as a diplomat number 1, what networks do you have, or what networks are you able to activate internationally that will position judiciary Kenya's judiciary in a global map that will also benefit judiciary in enriching its jurisprudence? That's number one as a diplomat. Number two, which institutions, development partners, etc., are you going to engage a network so that besides getting money from Treasury, as Commissioner Ishoi was engaging you on, we can also get money from elsewhere. We get another stream of resources that can also help judiciary to grow in terms of infrastructure and also even training. So could you tell us the two?
Okay, as diplomat number one, I don't want to tell you that as I sit here, there are 2 or 3 institutions I can go and knock and finances are being unlocked. I think I will be lying if I were to say that. But as I've been in the judiciary, we have had development partners, IDLO, embassies have been supporting the judiciary, the World Bank has been supporting the judiciary. I'm aware there is a facility to fast track from the World Bank which has not been activated to fast track this digitization, the typing of the proceedings in form of recordings.
Yeah.
It has not yet taken effect. So if I become that diplomat number one, instead of relying on the judiciary, it's not that I want to tell you that I will open the floodgate of finances, but it will be a matter of trying to go and get more resources instead of relying from one stream, and which has been done, and the developing partners are there to assist. We have the European Union, they are there. You have to go and ask and see what programs you have, because you don't want to go and just say, can you assist us with ABCD? We have libraries here which don't have books, or even an e-library where we can interact and have the books sent online, and the library becomes functional for each and every court. So you have to go and look for these resources, and the development partners are there. We have different embassies represented in these countries. You have to go there. We have the Association of the Commonwealth. You can go there and explain your needs. It's a matter of not borrowing, but pleading that can you assist?
Very well.
So yes.
Very well. Thank you. You have answered. Finally, or final now, is I've gone through your CV and all your documentation. Have not seen anywhere that you've indicated that you have participated in any community service. So my question is, could you please explain to us your philosophy of public involvement and past practice of giving your time to community service anywhere, back home, in Nairobi, wherever you have worked?
Okay, I don't believe in writing a long CV to the extent of making it boring. I've seen CVs, you attend a one-day seminar, you write an article in the Nation, you write, you do this, you write. It's not that I've been operating as an island. When I started practicing, I was a board member of my former school, Msambweni. That time it was a Harambee school. So I was a board member there until I joined the judiciary. So for almost 7-8 years, I was a board member and I served the community. I was a board member of Matuga Secondary School. It's a girls' school. I served there the community. As an advocate, I dealt with a lot of pro bono work. The murder cases, I handled them pro bono. being a local advocate who had just opened his office near his county, I've dealt with a lot of free services to the Wananchi. I've attended so many Harambes, in fact as a guest of honor, to contribute to these schools and build them. I've sponsored many students. You know, as a Muslim, you don't want to be you don't want to be seen that you are beating your trumpet. I've done some of those things become personal.
Very well.
You do, but you keep quiet.
You've answered. Thank you. Thank you, Chair.
Oh, thank you very much, Judge. And just once more follow-up question as we conclude, Honorable Judge. And unless I didn't hear you properly, Judge, you said that you don't believe in resource-oriented leadership. If I heard right, maybe explain to us why, because I thought we are all advocating for resource-oriented leadership.
Okay, the leadership comes in many forms. So there is the leader who wants the results. I want judgments to be delivered. Those are the results. But you don't care whether this judicial officer has the facilities to deliver those judgments. So don't concentrate so much on the results. It's not that we don't want the results. We want the results. But can you also be a leader who ensures that the results are produced through certain processes which enable the producer of those results to produce them? So there is that leader who wants profit at the end of the year. Everybody wants that. But if now you take the whole blood out of, you suck the whole blood out of your employees just because you want the results, I think the following year you will not get the results because those employees will be too tired to give you the same result. So there should be the balance between the results and the process. I think in my MBA you read about the Harvard studies or Ohio studies and whatever, where questionnaires are sent, and all what they come to is the results should be secondary, satisfy the employee's needs, good working environment, good working processes, the results will come automatically.
Okay. The other small clarification, Your Honor, is about, there's a lot of literature, I'm sure you read it when you did your MBA, about leaders who fail to achieve the results because of lack of this concept now called emotional intelligence. Even though they are intelligent in terms of IQ, they are very good technically, but somehow they fail to achieve what they want because of lack of that. I would want to hear your views about that, and whether your MBA helped a bit in that area, Your Honor.
Thank you, Commissioner. You know, emotional intelligence is something whereby the leader has to have that humility in him and be touched by the activities of his staff. During our MBA studies, there are those who fail. We are reading that the CEO of Microsoft, Bill Gates, will take 2 hours to respond to emails from his staff, who are 36,000 then. 2 hours just to interact with them. So that brings in the issue of emotional intelligence. At least you will be able to know the feelings and emotions of your staff. But if I come back to the results-oriented, we can be churning in judgments and reduce backlog for 2 years, and then the 3rd year, the backlog shoots up. And we have to go back to the drawing board. What happened? What went wrong? Because the leader came in with threats. if you don't do this, I'll take you to the JSC. There are no emotions. You are just there. Your emotions is I want the results. So you don't care whether the staff is sick or not. So the leaders fail because they don't interact with the problems of their staff, because it's the staff who are producing these results. I believe I can stop there.
Wrote to certain vetting bodies to get information on all the candidates, and I just wanted to ask you a few questions concerning the information we got about you. In the job advertisement, you are required to give us 2 character referees. You gave us only one, who was in fact non-responsive. And I just wanted to know from you, is it that you don't know that many people who can vouch for your character, or why is it that you just gave only one referee?
A referee on character?
Yes, a character referee. You're required to give 2.
Whom did I? Okay, maybe it. I don't know whether it.
There was, I believe, Professor Eshiwani. I believe that's the one that you gave.
Oh, okay. I'd not interacted with him for long. He retired from the university, but he has been my mentor. And I thought I was supposed to give just 3 referees, which I gave that one, and I gave 2 professors from Masinde Muliro. I don't know whether they responded because it was meant to be. But I gave 2 referees from Masinde Muliro University, Professor Matanga and Professor Okoth, who can vouch on my character. For the last 3 years I've interacted. I have so many people I can write, but you don't want to be seen to be bringing in your friends to evaluate your character. I believe you can be my referee, but I'm not saying that. You have known me for many years. So it's not that I don't have people who can be my referees, but I just thought any 3 could do, and I thought maybe had you told me you are not able to reach Professor, I would have given another one.
We also got communication from the Kenya Revenue Authority that you are not compliant. And the communication we received was that the reason why you are found uncompliant has been communicated to you. Would you care to just shed light on the reasons why?
Okay, when you advertised, I went to them and they gave me the compliance. They summoned all of us, and KRA kept on picking each and every power bill you have, and then you go there and engage with them. So I sat down with them, and they said, because whatever is earned out of my salary does not come to me. I can provide the bank statements, whatever I don't receive any rental income myself and put in my bank. It goes to my wife and she deals with the KRA. But they could see that there are some electricity accounts in my name. So I sat down with them more than 3 times, and I have documents here. They told me, okay, for this one your wife is doing, it's okay because it's being paid monthly. There was a time we didn't know that it's yearly, and we were penalized and we paid. So they said these other ones are not captured. We computed and it came to a penalty of 512,000. I paid that amount, and as of now I'm receiving the generated computer demands. So when they were doing the report, they said since this is time bound, we will send the report but with a rider that you have agreed to comply. So I expected that after I paid whatever I was adjudged to be due from 2018 to 2021, maybe they would send another reminder that now I'm compliant. But I'm ready to go back to them and ask. We have to give to Caesar what belongs to Caesar. I'm not refusing to pay. In fact, I told them whatever is in my name, part of it does not belong to me, belongs to my brother. But since as a leader in the family, you have to take some of those problems. They say, but since the bills are in your name, we take it that it's your property. But we agreed. They had a higher differences, saying this number of properties. I told them to send somebody there to count how many properties. So we agreed. I have agreed with them. I came to the Commissioner of Domestic Taxes. He had four officers. I was taken to opposite Radisson there, where the actual computation is done. I sat down with an officer by the name of Gideon. We came up with what is due. I was taken to another officer who would open the computer and open my account and post what is due, and then I was told to go and pay, and I paid. I can provide the payment evidence. I can provide the computations by the KRA itself.
Thank you, Judge. But I take it that whatever issue KRA had with your tax compliance has now been resolved, and you should be able to get communication to that effect before we complete this exercise? Okay, thank you. And the other issue I was able to pick up from the vetting documents is your wealth declaration forms. We required you to file the last 3. You filed only 2. And you did not disclose in your wealth declaration whether you have bank accounts, which I presume you must have, and the balances in those accounts. At the same time, you failed to file a statement in respect to your spouse. Could you please explain to this commission why?
A misunderstandings of those instructions, because we have been filling these wealth declaration forms every 2 years. So I didn't know whether you were supposed now to fill 6 years back. Maybe if I can be told we are in 2021, if I were to fill, I have the wealth declaration forms for 2017, I have a copy, and 2019. So I don't know whether that will suffice, or I have to go back and look for another one of 2014, because they are filled after every 2 years, I think, in my understanding. So when I provided the ones for 2 years, I thought they will cover. I have also to. I thought they will cover the necessary period. Maybe you comply.
Yes, Judge, the instructions were that your spouse, or a financial statement for your spouse, and that did not accompany your wealth declaration.
I'm sorry for that. When I read the instructions, I thought when you file your wealth declaration, you have filed all the properties you have. But I can provide the bank accounts if I'm told for how long, 1 year, 2 years, if they're available. I can get them within a day or 2, and it's certified, because it's not something you generate, it's generated by the bank. You can counter check. For my wife, I need to know, do you want a bank statement, or do you want her wealth declarations? She's a civil servant. I have now to ask her to go and look for her wealth declaration forms and bring them. So if you tell me bring your wife's bank statement from point A to Z, I'll bring it. Bring your bank account, I will bring it. There is nothing to hide.
Thank you very much for that reassurance, Judge. We'll be looking forward to seeing
to observe the requirement by the Constitution.
Thank you, Madam Commissioner. I come from Kwale County. In form of diversity, it's one of the marginalized counties. And I'm Adigo by tribe. Kwale County has, Adigo is one of the 9 tribes of the Mijikenda. We are 9 tribes, so Digo is one of those 9 sub-tribes. I come specifically from Diani, which is Msambweni constituency, and division, I come from Ukunda division.
Thank you very much, Judge. And I think this brings us to the end of this interview, Honorable Judge. On behalf of the commissioners, I want to thank you for your time. I want to thank you for your patience. You have been very patient. I also want to thank you for your honesty and openness in answering the questions, Honorable Judge. And I'm sure the individual commissioners have heard you and will be making your decisions, and I wish you all the best on behalf of the Commission. Thank you.
Thank you so much for giving me the opportunity to appear. I think it's an honor when you are given this opportunity to come and be one of the candidates. We don't take it for granted. So I wish to thank the Commission for having given me this opportunity. I've answered the questions to the best of my knowledge. There is the question Justice Majanja asked about general interests. I didn't know that he was referring to a specific guidelines being given by the court. I'll be honest enough, I've not read a specific judgment of the Supreme Court which gave those guidelines. So if I didn't answer your question, it is out of not having come across that. And I wish you all the best. It's a task which you have to do. We need a new Chief Justice. And all what I can say is may God give you the wisdom to pick the best amongst us. And I thank you so much.
Thank you. Thank you very much, Judge.
That case of Kasamega, where is it now?
I was only in charge of electoral petitions.
You know, you got the petition now? He called you.
I told you, yes.
You remember it?
Yes, I did.
Very controversial case.
What is your impression? This thing is coming up.
It's us who are not fighting people now. You see, like once he told you there's a problem with the KRA, you have moved on. And
But I thought the idea was to get what the problem is.
you then need to explore the details. Two, we ask too many of the evidence.
Yeah.
You start with the evidence side. For example, have you received this? Did you seek to care? Have you resolved the issue?